as not indicated by your lordships on the last occasion,
Yes.
that the questions of law might be academic. There are certain individual problems and individual issues which have also been tagged. But my suggestion, subject to your lordship's approval and other side agreeing, for example, Mr. Divan has some individual issue of one individual. They can be taken care of on the administrative side with RBI, bank, Ministry of Finance, etc., for which we may not waste the time of the constitution. That can be one way of dealing. If everyone agrees, individual issues can be sorted out.
If, according to you, the constitution issues do not arise for consideration.
It is.
So we have actually we've circulated a compilation. Whether your lordships have had a chance to look at it, where we've placed before the court all the orders, the series of orders. I'm a little surprised that the expression used waste of constitutional bench's time, when a previous bench of this court has said that these cases must be placed before a constitution bench. So I'm going to read through the orders passed by constitution bench of this court, as well as smaller benches of this court, referring our matters to this constitution bench.
But
and I've placed all of that on record in
only a minute, Mr. Divan. I didn't mean in a derogatory sense that wasting costs. 5 honorable judges' time is precious. That's what I said. I didn't say that we are wasting it. None of us are.
Your Lordship, maybe some of the petition, according to my Solicitor General, may be right or wrong, but not the all. So my request only one point, Your Lordship. Serial wise, Your Lordship may touch the petition which have the constitutional point, deal it. Which doesn't have the constitutional point, it should be discarded.
See, one
and
thing.
the Solicitor General want to say the same thing. If there is a constitutional point, it cannot be academic. It will affect my future, my country future for at large. So each and every petition should be taken up, whether the petition have constitutional point to be decided or not. If not, keep it one side. If yes, seal it. Either it is academic or not. That's what I like.
See, normally what happens, may I say something? May I say something? Normally, when issues are raised before a constitution bench, I think it is the duty of the bench to answer them.
Yes.
But in the instant case, has it not become a fait accompli?
No.
So far as
I'm
order is concerned.
I'm not for a petitioner who has an individual grievance. I'm only on the constitutionality of the actions taken for demonetization. And it has not become academic. With great respect, I've read your lordship's observations on the last occasion. It has not become academic. The issues are live. The issues may arise in the future also. Therefore, my lord, the issues have to be decided.
Answering for the posterity is one thing, but to say something for or against the impugned action at this stage, is it not already a fait accompli?
It is not academic. We will show to your lordships, it is not academic. For example, the 1978 demonetization was actually decided. Individual grievances, whatever your lordship says. I don't have an individual.
Diverse points of view, the academic or not. Of course, they are must be well received. I don't say so. But in my very humble understanding of the matter as it stands today, since the notification has now gone beyond, and there is an ordinance, and the Act has replaced the whole thing, unless the Act is challenged in a proper perspective with reference to context. And what happens today? What grievance will survive today? If the Act is not under challenge, where is the question of going back for notifications? And I think it's essentially academic, an academic declaration which may have a large number of political implications. So the court will probably defer to the need for not entering into the kind of academic declaration.
In my petition, I have challenged Act as well as notification itself also on the basis of constitutionality. I am confined to the Article 77(1) only. Because now we are not following the constitution. This is a real fact. Everything going to be done by the cabinet without coming into the parliament. Every day tax is being imposed. Every day everything is going on. This is demonetization is also out of the same series. This is a first act. which was never placed
I
before
wish-
the parliament
I-
before declaring that it is going to be demonetization. Whatever you want to do within the constitution.
I only wish that the arguments
We
are
are
advanced.
within
One
the
minute,
constitution.
sir.
No, we are
Please,
within
sir.
the constitutional system. We are and
I-
within the constitutional system. Now today this is a constitutional bench.
Suggestion.
Yes,
If it suits your, if it's appropriate, we have filed a compilation of which sets out at the beginning the orders passed by this court. I think if we go through the orders passed by the Constitution bench and other benches referring the matters, it may serve a purpose. May I request you to just, there are 4 or 5 orders which have been passed by this court, including those framing the questions. I think that will indicate as to how this case has developed and evolved, and then we can progress further as to how we want to proceed to the next step. May I place those judgments? And
What we are suggesting.
Yes.
There are totally how many? 40.
About 58.
There are 58 matters, right?
Yeah.
Now, we will take one by one first. Let us see.
Yeah.
Supposing one for any reason has become infructuous, we need not keep. And only those, which are relevant, which are necessary, we will take up independently.
Very good.
Otherwise, there will be virtually, it is not possible to control also with so
You're
many
right.
petitions.
Very well. I might just indicate one factor.
Also be
Perhaps your lordships
Mr.
are aware of
Sharma?
it.
Your lordship.
Your case we will take up at the end. Nikal ka side mein rakh do, huh? Last at the end.
I am saying something else.
Sorry. Ho gaya. Order is passed. At the end, you take this case at the end. And then remove that case. Which is your case?
162
Huh?
of 2020.
No. Item number?
Item number 728.
So 728. Keep it at side, at the end.
You see, I want.
No. You should not say anything unless we call upon you to say. No. At the end. Ho gaya. Over. Yes.
No argument. One line only. You will say no person should be allowed to repeat the previous argument.
All right. Now your case is at the end.
It should be.
We will fix a separate date for you.
No, Your Lord.
Yes.
Oblige,
I
Your Lord.
find,
Separate day, maybe. Separate day for you. Right.
I find the large number of
So
increase.
your lordships may just recall that in a previous order which was passed by this court, the Constitution bench has held that no other court should entertain petitions, etc. So that's one order which I wanted to draw attention to. And all applications and petitions should be filed in this court alone. That's one order. The other order is when separate writ petitions came to be filed because of this direction which was passed by this court. What your lordships thereafter ordered is that we are disposing of the writ petitions, but we are granting liberty to each of the writ petitioners to file an intervention application to assist the court and the Constitution bench. So those writ petitions were also closed, allowing us to approach this court because probably you didn't want a multitude of writ petitions to be filed, and that is the status. So we are entirely in the court's hands, but I thought it may be useful to go through these orders first, and thereafter, of course, as your lordship suggests, proceed sequentially or whatever manner the court considers appropriate. So I was just seeking permission of the court if you would allow me to place these orders as they evolve, so that we at least know the orders which have been passed by this court coming to this moment. That is my only request.
Mr. Shyam Divan,
Yes.
we have also discussed
Very well.
just
Very
before
well.
coming, right?
Yes, yes.
Now, if the issue has really become academic,
Yes.
there is no point in wasting the time of 5 judges,
Yeah.
right? Now, we feel having regard to the passage of time,
Yeah.
if there is any individual grievance in any separate writ petition, we will tackle them.
Yes.
But otherwise, all these issues should we take it up at this stage.
It's not academic, Manoj. It won't be academic because as I'm now just on the last point which you correctly observe. If there are individual issues, the individual issues challenge will be at different levels.
Yes.
They will be at the challenge that, look, this particular statute is unconstitutional. Assuming it is constitutional, the action under the statutes is for whatever reason disproportionate, failing constitutional tests. So, as your lordship is aware, our challenges are layered. They are at different levels. So, there is an attack on the validity. Assuming the validity, as your lordships correctly hold, one thing I might just point out, I mean, it's just maybe of some interest because Mr. Chindambaram has already indicated that to the court.
Yes.
As far as the 77-78 demonetization is concerned, and we have placed that in the compilation, that decision eventually came in 1996 by a constitution bench, which examined threadbare the statute and thereafter went into the individual grievances and pronounced on the individual grievances by the constitution bench itself. So that judgment also we have placed in the compilation. So, I mean, not that that is binding on your lordships in the sense, but that's an indication as to how a previous constitution bench tackling an issue similar to this did proceed in the matter. They retained the matter and they eventually decided it. So, Manoj, I am only speaking now from the perspective of the individual whom I represent. We had filed a writ petition. This court said that please file an intervention in this lead case of Vivek Sharma. So that petition was disposed of. We availed that liberty and we have come here by way of an application, etc.
That, Mr. Shyam Divan,
Yes.
with due respect,
Yes.
that was a time perhaps that order was necessary.
Yes, maybe.
Now everything is settled
Well,
down.
may I answer that?
Yeah, yes.
1978 demonetization was by a separate legislation of parliament. Ordinance on
Use them. Yes.
The 1978 demonetization was by a separate law of parliament. Ordinance followed by an act. Now, earlier in 1948 or so, there was another demonetization by a separate act of parliament. Today, they have used the Reserve Bank of India, sections 24 and 26. Now, whether a demonetization of this kind, we will show it is really not demonetization. It is new notes for old. It is really not demonetization in the sense that any currency is declared legal tender. Whether a demonetization of this kind requires a separate law, debated in Parliament, ordinance of course, but debated in Parliament, and then Parliament could have modified it. Can you invoke 24 and 26? That's not academic. That is a live issue. And tomorrow, if this goes unchallenged or unadjudicated, they can invoke 24 and 26 today. Again, whereas the two previous examples of demonetization were by separate act of parliament. And my submission will be this kind of demonetization requires a separate act of parliament, and 24 and 26 does not give you that power. 1. 2. 86.4% by value of the notes were withdrawn. The immiserization of the poor, I'm not raising all those. Those are in another forum. It can't be argued before court. Tomorrow, can you 24 and 26 be used to declare as illegal tender, no longer legal tender, 100% of the currency notes? 86 can become 96 tomorrow. 96 can become 98. Can you use that power? Therefore, please examine the power under 24 and 26. If your lordship uphold the power, that's a different matter. But please examine the power under 24 and 26. Please don't stop us at the threshold to say this has become academic. It will become academic every time because the demonetization is overnight. And they gave you a 2-day window to exchange, a 2-day window in some shops, pharmacies, hospitals, etc. After that, it will become academic always in that sense. But it's not academic. Your lordships, I would implore your lordships to please examine the scope of the power under 24 and 26, whether a demonetization of this kind, withdrawing 86.4% of all the currency notes in circulation, requires a separate law debated by Parliament.
But may I assist by
Right.
2 points, I will raise.
Before.
First of all the other questions which are raised.
You say on the submissions made by
The distinction
Divan and
between an
Chindambaram
executive
on this issue,
I would-
appears to be
I would like to
justified,
respond to
appears to be right.
I would like to slightly respond to that. But the distinction between an executive order or a statutory order under section 26 and a demonetization statute may be kept well drawn. But the question is today, what are we asking for a declaration? Declaration about that?
No, what
Does
this
it
is-
meet constitutional requirements?
No.
Well,
Mr. Attorney, what is being sought to be argued is that whether such a demonetization can be done by exercising power under 24 or 26.
Yes.
Or whether it is necessary to have a separate statute for that. According to Mr. Chindambaram, the earlier demonetizations were by a separate act of the Parliament.
if the court were to ultimately hold on addressing these issues,
Yes.
ultimately hold, yes, it requires an act of parliament. And what kind of declaration? That will be again a declaration sense. Instead of this, you could have done that.
No, but then.
That's the only.
But if you hold so,
Declaration is-
at least in
required-
future, this can be prevented.
It looks very attractive for a future. But what I'm trying to say is, but even then, it is certainly in the wisdom of the parliament, the act has now been enacted.
No, you may
The act, I'm sorry.
you may not be able to undo something what has happened.
That's right. That's the first chapter.
For the future, whether this same kind of power should be exercised or not.
My only response is, would it be in the nature of an advisory jurisdiction by the court in future, you would do that?
The way it is said, not.
I only suppose it would not. Your lordships may not enter into an advisory jurisdiction.
Strictly speaking, it may not be advisory.
In a manner of speaking, it would be an advisory.
Though we may not unsettle something, but we can always lay down a law.
Yes.
No, provided lords are striking down a law. If a law is being struck down, you lay down a law. But if your lords are not going into striking down the notification, the question of laying down a law may not ordinarily arise. But I feel
Many
it
of
would be
the-
a very
Many of the leading judgments of this court are advisory in nature, subsequent. For SR Bommai is.
for a number of reasons. For a number of
The
reasons.
event had.
Lord, your lordship's,
I only
your
think
lordship's,
that
your
lordship
lordship's
treading on
power to give a declaratory order does not depend upon whether the matter can be, whether the relief prayed for can be granted immediately or you have to mold the relief. Your lordship's power under Article 32 and 226 and 142 is declaratory. You will declare the law. We need to know what the law is. Parliament needs to know what the law is. Government needs to know what the law is. When will this law be declared? If this case is not a suitable case to declare the law, the next demonetization also In the future, perhaps the same learned Attorney General will come and say, this has been done. So when will you declare the law? The declaratory power of this honorable court does not depend upon what relief you can grant and what relief you cannot grant. Kindly look at the language of 142. For this court is binding.
Before that, can we appropriate that? Kindly look at the questions which are raised.
See, there are two aspects. But what they are trying to highlight, I think, the petitioners is the procedure or the manner in which it was done. That is what they are highlighting.
Even while the court may be called upon to answer this very important question, the court will certainly enter into other domains. It can't answer it in abstract. It has to go into this question, whether the law should have been enacted and which is the outer limit of section 26. All those issues necessarily arise, and we have to enter into a wide range of issues in economic policy.
Not on
I'm not saying the law will not go into that.
Not on economic policy. The two aspects are different. Whether the government in its wisdom would take such an action is possibly beyond the pale of the court. But whether the manner in which it was done, the procedure which was adopted is a matter which could be considered, and that is where they're saying give a declaration on it.
Be able to satisfy the court, the manner in which the government had to do it had certain sufficient justification. But the court would then enter a justification process. Therefore, it's a very gray area in economic policy making, where the court probably, I think, will defer to the wisdom. And now we are therefore, why do you want to enter into the procedural part of it? So the Parliament has gone into it.
To come to that conclusion, should we hear or?
I quite see that. I don't say that we are averse to the court going to the question, but I only think that court will necessarily enter into wide range of connected issues which cannot then unentangle. Quite a number of issues are there.
Well, the laws travel far beyond what the learned Attorney General is saying. Your Lordships have now said every action will be tested on the doctrine of proportionality. Even if it's economic policy, it can be tested on proportionality. Therefore, the laws travel far beyond, my lord, all these 20-year, 30-year-old theories. Therefore, even if economic policy, I'll pose a question. Suppose tomorrow a government decides 100% of all currency notes will be demonetized. And if they're demonetized, but will you not, Lordships, not test it on the doctrine of proportionality? If suppose, well, the only currency notes that were available at that time in 2016 were, I think, 2 rupees was the lowest denomination. Suppose even 2 rupee note had been demonetized. Well, please remember, 86.4% represented 500,000 rupee notes. There were very few 2 rupee notes, 5 rupee notes, 10 rupee notes, 50 rupee notes, and 100 rupee notes. We think that they are the common currency in circulation. That is not so. C in C, currency in circulation, 86.4% was 500,000, and that was taken away. And tomorrow, you say exercise power under 24 and 26, I will take away 99.9%. Then the court is powerless to test it. It may be sound economic policy or unsound economic policy, but your Lordships can't test it on the doctrine of proportionality. Of course, your Lordships can. Your Lordships, I think one of your Lordships delivered a judgment in proportionality, Justice Ramasubramanian. There is a judgment of Justice Chandrachud and proportionality. We will place all those judgments. But to stop us at this, saying it's all academic, it's not academic. Please hear us for at least an hour, then decide whether it's academic or not.
Kindly do that. While adopting the submission, respectfully adopting the submission of the legislator. But essentially, it's for your Lordships to take a call, whether to hear it on merits or otherwise. We have filed our reply long back, and we have an answer to each and every question raised. But this is not the occasion today to respond to them on merits, and therefore we are not responding. But I must tell your Lordships, so far, whatever are the decisions rendered by your Lordships on your Lordships jurisdictional to interfere in the economic policy regime, your Lordships have so far not examined it on the ground of proportionality. And the reason is very obvious. It is essentially for the executive based upon several factors, which some of which may not even come in public domain, to take certain policy decisions immediately in an emergent situation. One of them can be terror funding. So, my lord, these are the issues. Lord, question is whether your lordship would like to go into it. If my learned friend wants it for an hour or so to decide whether the court should, my lord, go into it, Lord, your lordships may do so. But as the learned Attorney General, Lord, I am respectfully, Lord, adopting the submission that it may perhaps eventually be, Lord,
All right, we will hear Mr. Chindambaram or Divan, whoever, on this question for the present, and let us see how things take shape. Whether we should
Lord,
decide or not.
Yes, Lord, may I suggest, Lord, on behalf of both of us, Lord, if your lordship would like to examine for an hour or so, my lord, whether to hear what are the prayers, etc. Then, my lord, we may also need some time. Sure. The lordship may have, my lord, immediately on whatever date, my lord, possible.
One of the concerns which I want to share about, while all these arguments
Yellow. Let the petitioners begin. Let us see how, after some time, how things take shape. And for you, we will grant you time. There is absolutely no problem. Let them make a beginning today. What do
we
you
have
say?
no difficulty about that. Certainly, your lordships will have their answer on that.
What-
But I only want to share some concerns.
Huh?
Again, to not the cause of repetition.
Uh,
In to introduce arguments such as proportionality and inviting the court to get into certain very important questions of economic policy will be a very high decibel invitation. So I think the court may have to be very slow in getting into the argument, particularly in the realm of, say, now it's no longer a mere domestic banking decision. How will the government deal with a banking policy At a global level, we have so many issues arising in even domestic intervention. So the court, therefore I say the court will be very slow in getting in, because the moment the court goes into any one of the issues, then a wide vista is opened up.
Attorney, to make up our mind, we must hear them.
Your Lordship, I have no difficulty about that. I only want to flag this concern, that's all.
Even to understand what they are saying, we may, and for you, we will respond, we will grant you time, there is no problem. Or is it, are you saying that today, let us not begin, we will have it on some other day? Are you saying
That probably that would be desirable, so that we also take stock of all the arguments advanced today. We come back with a more structured way of addressing the court. Otherwise it becomes ad hoc.
No, but then,
Hearing.
if we hear them today,
Very well.
Yeah.
you will know what is to be responded on the next date.
I have no difficulty about that, but I thought some structured way of taking the time of the court and addressing the court, we should probably organize our hearing process. We are not, I don't think we have done it.
But then today's date was fixed with everybody's consent.
Yes, yes.
But of course, attorney was not there last hearing. We know that
Yes,
also.
I am privileged to address the court today on this very important.
Brother Ram. Yes, Mr. Attorney.
I thought let me formulate some threshold. Getting into all those questions the court has formulated earlier. I think some of them have really become academic. So a few threshold issues, the court can look into them and thereafter take a view whether you need to go further or not.
That is
That's
why.
why I thought more.
You want to know what the threshold issues are, we have to hear them.
Heard them.
By order dated
16 December
16th of
2016.
December 2016, 9 issues have already been formulated by a 3-judge bench of this court presided over by Chief Justice Thakur. I was there, Mr. Sibal was there. We gave draft issues, they have been formulated. If the learned Attorney General wishes to formulate more issues, we have no objection.
I want to reduce
These are issues have already been formulated. This is reported in 2017, 1 SCC 388. It's also in the paper book. 2017, 1 SCC 388.
Milord, may I make one submission, Milord? I appear for the Reserve Bank of India. Now, Milord, these issues, 9 issues, are all relating to, Milord, the notification. Subsequently, Milord, there have been legislation. Now, several petitions have come after these issues were raised. So, Milord, if my learned friends wish to address your Lordship on those, and some of them are in the list today, some are not. If they wish to, Milord, it would help, Milord, subject to what your Lordship will, Milord, if they were to indicate what are the issues on which they wish to argue. Because, Milord, then your Lordship will have in front of you what is it that your Lordships are called upon to decide. If your Lordship is starting today, Milord, no difficulty. If you're not, then, Milord, it may be a good idea, Milord, now that there is many more writ petitions than were there on the date of this order, for them to indicate which are the ones which they are addressing.
Or there might be some additional issues also.
There will definitely, because, Milord, the legislation and the ordinance and the act came subsequently.
They're not under challenge.
Judge, may I, with your permission, just read through the orders? Let us, if we go through the orders, all of this will become clear.
All right, let us see, let us make a
Very
beginning.
well.
Yes, let us make a beginning. Because if your lordship is just
There are,
pleased to
where is
take up.
that? Where is that?
Yes, so I have set them in a compilation. We've requested the court master
Where
to
is
keep them out. Just let us see our orders of our court. It's a compilation of documents in IA 26757 of 2018. Your lordships have that. I am only focusing on the orders. Let us just see how it develops.
But we are sorry, we can't provide chairs to all of you.
No, but we are just now. I just want to take your lordships through these orders. So let's see how it develops. To page 1.
Yes.
That's correct. Now, this, please note, this is the order which Justice, which Mr. Chindambaram was referring to, 16th December 2016, bench presided over by Chief Justice Thakur, page 1. Your lordships have it?
If my learned friends can give us a copy of these.
Yes, we'll give you a copy now. So give it to you. Yes. So I'll just read it.
Yes.
So, Manoj, writ petitions, your lordships will see that a whole bunch of writ petitions are admitted. Issue notice on the writ petitions, specially petitions and other applications. We have heard the learned counsel for the parties at some length. In our opinion, the following important questions fall for our consideration in this batch of petitions. Now, these are the 9 questions formulated. Please see whether the notification dated 8 November 2016 is ultra vires 26(2). Section 717 so-and-so of the RBI Act. This is what Mr. Chindambaram was projecting a short while ago. Does the notification contravene the provisions of Article 300A? Assuming that the notification has been validly issued under the RBI Act 1934, whether it is ultra vires 14 and 19, whether the limit on withdrawal of cash from funds deposited in banks has no basis in law and violates 14, 19 and 21, whether the implementation of the impugned notification suffers from procedural and or substantive unreasonableness and therefore violates Articles 14 and 19, and if so, to what effect? In the event that Section 26(2) is held to permit demonetization, does it suffer from excessive delegation of legislative power, thereby rendering it ultra vires? What is the scope and effect of matters relating to fiscal and economic policy of the government? This is the issue which was raised by the Attorney General and the Solicitor General. Whether the petition by a political party on the issues raised is maintainable under 32, and whether district and cooperative banks have been discriminated against by excluding them from accepting deposits and exchanging demonetized notes. Keeping in view the general public importance and the far-reaching implications which the answers to the questions may have, we consider it proper to direct the matters to be placed before a larger bench of 5 judges for an authoritative pronouncement. The registry shall accordingly place the papers before the Honorable Chief Justice for constituting an appropriate bench. Then, Manoj, there is a further narrative with your permission. I'm just skipping a few pages and going directly to page 6. Please go to page 6. Yes. The other broad point, your lordships have that? The other broad point on page 6. The other broad point was about extending the time limit for exemption for use of demonetized currency notes of rupees 500 and 1,000 at specified counters as per the relevant notifications issued in the behalf of the Reserve Bank of India. It was contended that the exemption period provided in the concerned notification is expiring. Hence, it will not be possible to deposit the demonetized notes at specified counters thereafter, even in case of emergency situations like hospitalization, travel by air, by railway, air, etc. In our opinion, whether the exemption period should be extended or not must be best left to the judgment of the government of the day, with a hope, this is important, that the government will be responsive and sensitive to the problems encountered by the common man. Accordingly, we decline to issue any interim directions to the government in the matter of extending the period of exemption and leave it open to the government to take appropriate action in this behalf as may be advised. Now, please go overleaf to page 9, second last paragraph. We further direct that if any other writ petitions or proceedings are pending in any high court, further hearings of those matters shall also remain stayed in terms of this order. We further direct that no other court shall entertain, hear or decide any writ petition or proceedings on the issue or in relation to or arising from the decision of the Government of India to demonetize the old notes of rupees 500 and 1,000, as the entire issue in relation thereto is pending consideration before this court in the present proceedings. we make it clear that the petitioners before the High Courts or others, etc., in respect already instituted and subject, will be free to intervene in the writ petitions pending consideration before this court on the subject matter of demonetization of old currency notes of rupees 500 and 1,000, registry to place before Chief Justice. And your lordship may just, there is an earlier page, paragraph on transfer petitions, which I should have also read, paragraph on page 9. That takes us to the transfer petitions filed by the Union of India for withdrawing all the writ petitions and proceedings pending in various high courts across the country to hear those cases along with the writ petitions in this court. So at the instance of the Union of India, it was consolidated here. Your lordships have passed these directions requiring all of us to come here before this court. Now, this was the order passed on the 16th December 2016. Now, this evolved. Now, please see page 11, which is the next order dated 6th March 2017. Now, this is a bench presided over by Chief Justice Kehar, and your lordships will see those names on page 14. But I will just mention here now there are several writ petitions over here, which are fresh petitions filed, page 11. Your lordship has that. Now, please see, yes, so these are individual grievances. Please go to paragraph 2 on page 11. Very well, I'll start from the top. Learned Counsel for the petitioners in the first instance invited this court's attention to the speech delivered by the Honourable Prime Minister on 8th of November 2016 with reference to the demonetization scheme. A pointed attention was invited to paragraphs 9 and 10 thereof, where it was clearly expounded that such of the persons who could not get their old notes of 500 and 1,000 currency notes by 30th December 2016 would be permitted to do so at specified offices of the Reserve Bank of India by 31st March 17. The court's attention is also drawn to the notification by the Finance Ministry on 8th of November, which envisaged that old currency notes held by individuals other than banking companies would be permitted to be deposited subject to specified conditions. Condition 9 in paragraph 2 postulates as under: any person is unable to exchange or deposit the specified notes in their bank accounts on or before 30th December 2016 shall be given an opportunity to do so at the specified offices of Reserve Bank or such other facility until a later date as may be specified by it. Based on the aforesaid condition, it was submitted that the notification dated 8 November 2016 was in consonance with the speech of the Honourable Prime Minister. The predicament faced by the petitioners emerges from an ordinance number 10 of 2016. So now the ordinance has come after those questions have been formulated. Issued on 30th December 2016, an extract of paragraph 4 of the ordinance is set out. Exchange of specified bank notes for one, notwithstanding anything contained in section 3, the following persons holding specified bank notes on or before 8th of November 2016 shall be entitled to tender within the grace period with such declarations or statements at such offices of the Reserve Bank of India or such other manner as may be specified by it, namely, and then it talks about citizens of India who make a declaration, and number 2, such classes of persons and for such reasons as may be specified by the notification. So this will specifically come up in this batch of petitions. I'll indicate how. Please go to paragraph 6. Based on paragraph 5 extracted above, so then there's paragraph 5 of the ordinance, it was submitted that an avenue has been postulated for dealing with deposits even after the expiry of the grace period of 30th January 2017. It was pointed out that despite the aforesaid postulation in paragraph 5, no individual has been permitted to make deposits of old currency notes after 31st December 2016. It was submitted that the petitioners had genuine reasons for not being in a position to deposit the old currency notes by 31st December 2016, and yet no attention was paid to the predicament of the petitioners, even though the petitioners had brought out their grievance to the notice by the competent authority. Issue notice returnable, etc., and therefore the petitions were entertained. Then the next order of importance is at page 17. Please go directly to page 17. This is my petitions, is one of the petitions in the caption petition, page 17. This is an order your lordship will see of 21st of March 2017. Please go directly to page 19. Page 19. Issue notice. On our asking, Sri So-and-so Learned Counsel accepts notice. Having heard submissions which remained inconclusive and before proceeding further with the matter, it was felt that this court should ascertain from the Union of India, A, whether the central government intends to exercise its powers conferred under 412 of Ordinance 10 of 2016, and B, if the answer to A is in the negative, the reason why the central government chose not to exercise its jurisdiction, an affidavit may be accordingly filed by the central government explaining its position. This affidavit is also filed, which we will come to, but I'm just pointing out. So this issue of section 4 or clause 4 of the ordinance is very much an issue, and this court directed at that point of time. Now, please see the final, the last of the orders, important, 3rd November 2017. Now, this is begins at page 20. This is a bench presided over by Chief Justice Deepak Mishra, and your lordship may go directly to page 22. Now, please see, there is a huge batch of writ petitions in the caption. Your lordship say, because now all petitions are consolidated, all have to be filed before your lordship. This included my petition as well. Having heard learned counsel for the petitioners and Mr. Venugopal, learned Attorney General for the Union of India, we think it appropriate that the petitioners should file applications for intervention or impleadment in Vivek Sharma versus Union of India. It is hereby made clear that they can assist the court when the matter is argued with regard to the constitutional validity of the law. That apart, their individual grievance may be dealt with by the Constitution bench, keeping in view the ultimate decision of the larger bench, or if it is otherwise possible, the instant petitions are accordingly disposed of. All pending interlocutory applications are also disposed of. And then one of the petitions is rendered just the infructuous, the last one. It is submitted by Mr. Puneet Jain, learned counsel for the petitioners, that the writ petition has become infructuous. This is because cooperative banks were extended a facility which they were not given earlier by a notification, etc. They were allowed to make the deposits. So therefore, this petition, which was filed by the Jain Cooperative Bank Limited, etc., had become infructuous. So that was closed. The other petitions, including mine, were referred to the Constitution bench, as you have seen. Interventions were allowed to be filed to assist on the constitutional validity of the law. Now, this is the state, your lordships may just note, as far as the orders of this court are concerned. Now, there are a couple of things which I should just mention to you. The Attorney General made a statement on this day, which is actually reported. It's not recorded in the order, but I'm just for completion indicating on the 3rd of November 2017, where he, and we have at page 84 of the same compilation, there's a news report, but I'll just summarize it for you. The difficulty was that once this new act came, holding these currency notes became a prosecutable offense. So people like me had currency notes in 1,000 and 500. We had come to the court and there was a potential prosecution which was being faced. So the Attorney General very fairly made a statement that as far as these petitioners with regard to the notes which they have disclosed, etc., because we made a disclosure in our petition of exactly how many notes we have, there will be no coercive steps which are taken against them. So this is now the background over here with respect to the orders passed by this court. Now just have a look at page 101. I'm not reading it beyond pointing out as to what. So just go to 100. Now this is your lordship's Constitution bench judgment rendered, as you will find at page 101 of the compilation, on 9th of August 1996 in the context of the Demonetization Act of 1978. Your lordships have that? Now, this is again by a Constitution bench, which your lordships have noticed at page 101. I don't want to take your lordships' time over this, except to say that apart from the issue which Mr. Chindambaram had pointed out with regard to the magnitude and whether this power can be exercised at all, the other element which the Constitution bench did is, after examining whether the act and whether the action was constitutionally infirm or not, went into the individual cases of the writ petitions. I'm just pointing out, it happened before the Constitution bench. Even though this was 18 years down the line, 1978, judgment eventually rendered in 1996, but the guardrails were set by the Constitution bench at that point of time in the context of whatever was done way back in 1978, not dismissed as academic. And then for individual grievances, it was examined by the Constitution bench. And you will find that, for example, at page 109, individual writ petitions by various cooperative banks, etc., and their grievances are examined and then dealt with by the Constitution bench itself. So I would respectfully submit, now that your lordships have a very good idea of how this matter progressed, how we are all before this court. Why? Because this court said, don't go elsewhere and come here. Once this court says come here, once this court says it is to be decided by the Constitution bench, to borrow your lordship's expression, it then becomes the duty of the court to decide. Now, Manoj, we are not insisting on whether it is to be decided today or tomorrow. But to shut us out and say that the issue is academic, as is being suggested by the other side, is, according to us, completely improper. Now, Manoj, to answer that other point, there are, as you have seen from so there are substantial questions which are framed, which are already there. Then you have two statutes. So may I just point those out from the compilation? Page 38, just have a look at 38. I'm not going to read anything. 38 is the ordinance, which is subsequent to the framing of those questions. 38. This has the appointed date, clause 3, clause 4, and it came to be substituted by an act which is at page 53. So it becomes Act 2 of 2017.
Shyam Divan,
Yes.
Just on fact.
Yes, yes.
See, the earlier demonetization.
Correct.
You have seen Justice Mukherjee's judgment.
Yes.
Is it similar to the present one or it's different?
The answer is yes and no. The answer is yes, because it was, of course, a demonetization of currencies, etc., and a question of whether there was power under the RBI Act to do so. The answer, so to some extent, yes. So there will be some guidance to be obtained from that. But as Mr. Chindambaram mentioned a short while ago, in terms of texture, this is a very different situation because it's over 86% of the currency notes. So
What was the percentage earlier?
it was a very small 1.8%, very high denomination notes.
10,000 rupee notes and 5,000 rupee notes. Which your lordship remembers, 1978, hardly anybody would have seen a 5,000 or a 10,000 rupee note. Today, you have demonetized 500 and 1,000. Somebody, my lord, Rip Van Winkle thinks that 500 and 1,000 are scarce notes. They are not scarce notes. They represented 86.6% by value. You have taken away 86.6% of the currency in circulation. Therefore, my lord, they are similar, as Mr. Divan said, similar but dissimilar. Your lordship will get some guidance from Justice Mukherjee's judgment, but your lordship will have to go further and examine the enormity of this demonetization.
So, sorry. So, just to
The other thing, perhaps, if I remember, those 10,000 rupee notes are very big, you know.
Hardly any, I have not seen a 10,000 rupee note.
I am assuming in those days.
There were large notes. They stopped issuing those notes long ago. There were some notes which were available. Similarly, the earlier demonetization also was a separate law, but that again was not the Mahatma Gandhi series, but the King George or whatever series. There were very few notes at that time in circulation, and therefore they said demonetizer. But you have taken away the bulk of the currency in circulation. And to say that this cannot be examined, this is economic policy. My Lord Justice Ramasubramanian's judgment is on cryptocurrency, virtual currency, policy of the government. RBI issued a circular. Your lordships have held that the circular is illegal by testing it on the ground of proportionality. What else is cryptocurrency and virtual currency? It's an economic policy of the RBI. RBI said we will not allow virtual currency. That's an economic policy which the RBI is implementing through a circular. Your lordship has struck it down on the ground of proportionality. Therefore, my lord, your lordships would have to hear us for some time even to come to the conclusion whether it's not academic. But we are confident we can satisfy your lordship. The issues are not academic, they are very live issues.
If I may add, Miller, to answer the query raised by Miller, so that the earlier.
No, the Act is still in force. The Act
yes,
is
of
still
course.
in force.
Yes, of course. The Act is a very
The
much.
Act is still in force.
Yes. Yeah. And it
Maybe I'm just.
no, it is in force.
If they withdraw the Act, then repeal that, then perhaps it may become infructuous. Is it so?
No, Milord, it still won't be so long as they give us value.
The Act is now occupying the field.
No. If you repeal the Act, probably then.
Then it will be a different, story altogether. Why should we? Why should
one
any one
thing
of us get into those hypothetical questions?
No. Just.
I understand. I understand. These questions are bound to come. We're bound to answer them.
Well, one thing is the act, the other is the notification of 8th of November. That notification of 8th of November is the one that is squarely challenged, apart from 24 and 26. The notification of 8th of
Mr.
November,
Chindambaram, notification is issued in exercise of what power?
exercise of powers under section 26.
Of the Act.
Yes.
RBI.
RBI. All right.
So, Milord, just to wind up, I might just indicate in this compilation, you need not turn to it. We have also set out those impugned notifications. So they begin from page 31 onward, just for convenience. So that the notification, there is the Prime Minister's speech on 8th November 2016. There is the statutory notification at page 31. There is the Reserve Bank of India and the Press Information Bureau press statements which they have issued at pages 35 and 37. These are the subject matter of challenge, or to say that, look, we draw sustenance from these particular provisions. These provisions, speeches, etc., indicated that even after 31st of December, at our Reserve Bank of India branches, etc., there will be some specified branches, there will be facilities which were made which will be available. Then in this compilation, I've just placed it. I'm not going to take you to it. The facts as far as I am concerned. So I placed my writ petition which I had filed before this court. I was told that no, come with an intervention application, which is why I'm here before an intervention. I had left the country in April 2016. I returned in February 2017. When I had withdrawn some money. I'm telling you the real issue. This was hard-earned money which I had kept because I had to undergo a knee surgery or something, so I had kept it. I have all those deposits and those particulars. When I come back to the country in February 2017 and make a request that, look, please exchange these notes, etc., I am told, no, that can't be done. It's 1,62,000 as far as this particular party is concerned. It's very, very important. Hard-earned money, you cannot nullify it. So therefore, the constitutional elements come in. 300A, of course, 19(1)(g), 14, proportionality and livelihood, which we'll come to, on life at any rate. But we'll deal with that at an appropriate stage. And the final thing which I'm just mentioning in this particular compilation, we've actually separately e-filed another compilation, but e-filing I've also given a physical copy. You needn't turn to this. Here, you needn't turn to it. But I want to just mention one thing, what the Reserve Bank of India said. The Reserve Bank of India said that that 16,000 crores worth of these notes, which are the specified bank notes, the value of which was specified, 16,000 crores worth was left outstanding. That is what their statement said on 30th August 2017.
What do you mean
Before
by
your
that?
law.
What do you
All
mean
right.
by that?
So what they said, so your lordship recalls that at the moment demonetization was announced, there was a window given for exchange of those notes,
Yes,
etc.
yes.
So basically it fell under two schemes. The Prime Minister very fairly said that, look, the last date is going to be in December 2016 itself. However, for appropriate cases, there will be some extension which is to be granted. That was obviously consistent with the government thinking and policy at that point of time. Thereafter, on 30th December 2016, they introduced an ordinance which said that, sorry, the last date is not going to be anywhere in 2017. It is going to be 31st December 2016 itself. And we are not going to allow any extension, though the ordinance provided for that provision under Section 4, which this court asked the central government to file a reply that, look, are you planning to exercise this power under Section 4 or not? So that's a separate issue. Now what happened? So to answer the question, what the Reserve Bank of India said is that all the currency notes which were cancelled, I'm just using the expression cancelled, or the specified bank notes of 500 and 1,000, which they have received back, it constitutes 98.96% of the notes which were in circulation. But 16,000 crores worth of notes are still outside. This is Reserve Bank of India's statement. Out of that 16,000 crores worth, there may be some which are, which don't justify any leniency or any extension of benefits by the government because they may be unauthorized. So we are not talking. But in genuine cases like mine, where I was overseas, I came back, I have full disclosures. Even those people, in my case, 1,62,000 are completely shut out. So I'm left with holding these particular notes which are of no value. And thanks to the Attorney General's statement which he made, which I indicated to your lordships, we are not being prosecuted. Our notes are with us. We are before this court on this issue. Very important. It's not just some abstract principle. As far as I'm concerned, it's a question of my hard-earned money which has been rendered naught. So that's the issue. So Manoj, these dimensions are far from academic. They are very, very much alive. And Manoj, I think Mr. Chindambaram will have on the larger issues a lot further to share.
Your Lordship's last question.
Only,
Yes.
Shyam Divan,
Yes,
before
yes.
Chidambaram starts, that money is still with you without any value, even.
Yes, exactly. It is still with me. And so the answer is yes. It is still with me. In my application now, I have given the specifics as to how many notes of 500 really requires a full hearing, Manoj. I mean, having got us all to come over here and make these submissions. Now, please don't tell us that it is academic or send us back to some other court. Because your lordship, see, they move transfer petitions from across the country and wherever else, we've all come over here now and we waited. So now that your lordships are sitting on a panel of constitution bench, 5 judges, I would respectfully submit that, I mean, it's not going to take very long. I'm sure even on the merits, we will not be taking all great lengths of time and far from wasting the the time of the court is, I think, going to be very beneficial because the guardrails eventually are set out by this court as to what governments can do, what executives can do, and what they can't do. Grateful.
Only one interjection, my lord. Since, my lord, hard-earned money, this, that, and others, that is also taken care of by the Act Section 4. Possibly, there must have been application made and rejected. Possibly, we'll check up. So it's not that hard-earned money, my lord, is taken away.
Made and rejected, is it? Made and rejected.
Possibly, we will have to check up. So it's not as if hard-earned money of everyone goes. There are statutory protections given that you can convert it.
And to
And
answer,
the government, obviously, my lord, would be fully aware of this situation. I didn't want to interrupt, but he said hard-earned money taken away. That's not good. That's
to answer the submission that the 1978 Act, those writ petitions of individual cases were considered by the Constitution bench for good reasons. Kindly to depict 109 of the order judgment of the Constitution bench, there was an appellate provision under the Act. Appeals were filed. Appeals were rejected. Thereafter they came to the court. Therefore, they were heard again. So it's in an entirely different context, not because the petitions are being tagged along here, they have a right to be heard. So if the
Petitions have been tagged at your instance.
the autumn time pointed, there was a reason why they were heard.
Petitions have been tagged at your instance.
Because you didn't want it to face the music throughout the country, that's all.
There is very important reasons. Very important reasons.
Lord, I was there, my lord, therefore I can say, not face the miss. My lord, the idea was there were conflicting orders being passed, interim orders being passed. Therefore, we say that this is a pan-India issue, let the Supreme Court take it. That was the issue.
A matter of moment at that point of time. Therefore, the orders are being passed. So I come back to those 11 questions, the 9 questions. In my very humble submission, many of them are academic. I repeat that statement. If you look at this question, what's the scope of judicial review in matters relating to fiscal and economic policy? I mean, one more chapter to be added by this court in a matter like this. And then again, the next question, whether a petition filed by a political party and the issue raised is maintained with Article 32, does it have any connection with this issue? Therefore, these issues probably are absolutely irrelevant to this point of time.
Mr.
So maybe
Attorney General, what it is we are thinking is, now the Act is in force.
Yes.
The notification is still in force.
Yes.
The notification issued under Section 24, right?
The Act is taken over.
It is operated already. What is the correct way?
No, operated means it has come to an end, is it? Whether it is time bound, the notification.
Yes.
No, was it for a specified period?
Because
Yes.
certain consequence follows on 31st of December. That consequence is already
Therefore,
followed.
it has worked itself out.
Maybe we may
Therefore,
have to examine.
The Act now occupies the field.
We may have to examine, Mr. Attorney General.
But then I would probably advise the court that there was limited threshold examination of what would be, if at all the court may have to go further in this matter. I thought a limited threshold examination.
What is the prayer
essential
sought in the expedition?
Your Lordship, please.
What is the prayer sought in, at least in?
To set aside the notification.
Exactly.
That's right.
That notification
Therefore,
is fully in force.
even if you set aside the notification, the act is in force. So therefore you can't have a. That's why it's an academic declaration.
No, in some of the petitions, the Act has also been challenged.
Act has been challenged, like 24 and 26.
So it won't become academic in that sense.
And above all, we can only say academic or infructuous, because both sides agree. But if there is a point and a counterpoint, even to say whether it is infructuous, whether it is.
I quite see that. I quite see that. But only the concern is, before going into the larger canvas which persuaded the government to enter into this very important exercise. I mean, to lay down for the court all those very important considerations taken by the government. And it certainly
That is why
the court that
the earlier denotification, though, if I am right, it is 78, is it, or 76?
no, that was
This not examined in which year? 92, is it?
96.
18 years later.
We are the distinction between the 1978 Act and what's happening today is a very important distinction. A large number of developments in economic policy, banking policy, globalization, and impact of monetary policies across the globe. There is a large number of issues, corruption, black money, whole number of issues being taken into consideration by the government. Therefore, my only concern is to what extent the court will enter into all these
That of course we can decide only after hearing both of you. We are not able to make up our mind right now, you know.
I understand. We are only trying
We are
to
not
track
in
the
a position
concern.
to take
No, that argument is always available to you. What is the scope of our judicial review?
But
What are the limitations? So while examining their submissions, you'll always be guided by those principles.
I'm not restricting that at all. I'm not saying that at all. But only saying that my concern is the moment you also get into any one of the issues, then there are further issues which keep cropping up. Therefore, I was trying to look at the issues. How many of them are academic today? Will the court go into all those issues at all? Probably that's why I said let's have some threshold for issues.
How can you say that?
Like to go into.
How can you say that issue number 7 is only academic?
No, it's not academic.
What is the scope of judicial review in matters relating to fiscal?
There are any number of your lordship's pronouncements on that. Any number of them.
Therefore,
Going back to your lordship.
Therefore, in order to answer that issue, we'll have to hear and give our answer to it and say whether it is academic or whether it is not academic or whether it is beyond the scope of judicial review. See, the point is, as I already said, the government policy, the wisdom of the government is one aspect of the matter. We all always know where the Lakshman Rekha is. But the manner in which it is done, the procedure is something which can be examined and an answer can be given. But for that, it is necessary to hear the counsel, learned counsel.
Exactly. So there is no resistance to that at all.
Yes.
I'm only repeating my concern that even the manner part of it, the procedural part of it, if the court may have to say, yes, the procedure was absolutely, inappropriate, ill-advised, then the court probably would enter into a domain where the wisdom of the procedure followed would also be a matter for declaration by the court. Therefore, in that context, how far the court would travel?
So any declaration.
How far the court would travel?
See,
Yeah, that's why these concerns are being flagged.
Any declaration one way or the other, any declaration one way or the other is for posterity. And I feel it is the duty of the Constitution bench to answer it
Without
one way
doubt.
or the other.
Without doubt.
Yes.
But your lordships know that in certain momentous decisions taken by governments at given points of time, there are several considerations which are very persuasive.
Correct. While answering it, we would take into consideration those considerations.
But by only
We understand your apprehensions.
Lord, today your ladyship or my lords may not conclude anything. Let it be heard on some day.
Yes.
Without, my lord, any further orders today. Your lordships, my lord, have the conspectus of the matter on both sides. We'll address your lordship.
Know whether there is a point and a counterpoint which requires consideration.
Yes.
Everything is in
So we
line.
should be satisfied.
Yes, my lord. Taken away suddenly and have no remedy. While taking that decision, even the hardship to be faced by honest people like Mr. Divan's client, they're also taken into consideration and provisions are.
Because my lord, your lordship will recollect that every my lord, exemption which is given under this scheme creates my lord, a huge my lord, impact. People try to take advantage of that exemption. So it was important to confine the exemption to very narrow limits. Otherwise, there has to be one cutoff.
All right, what we suggest is let Chindambaram make his submission and let us see, we will see after some time and we will grant you time, there is no problem. But let him make a beginning, let us see how things take shape, right? Mr. Chindambaram, please start.
But our response, the learned AG and me.
No, we will grant you enough time, nothing.
You know, whatever I was trying to place your lordship, only with a certain amount of concern, you're opening a matter like this of large implication. We're not seen as, not inclined to assist the court. That's not, but there are concerns which unfold over a period of time. It is a point I want to be very careful about.
But we have answers, our affidavits are in detail and dealing with every submission, which we believe you will satisfy lordship's conscience.
Yes.
Even they will not conclude today, probably only.
Yes.
The overview of them.
We will grant you enough time, nothing to worry. This can't be rushed through also, we know that also. But unless we make a beginning, how will you, Let us start, let us see. Yes, Mr. Chindambaram.
Very well,
Please.
I'm grateful.
Yes.
My lord, let me indicate the scope of my arguments, a broad overview of my arguments. And whenever your lordship wishes to go into the questions more deeply, I will assist your lordships. So the first question is, does the government have the power under Section 26 of the RBI Act to make the notification, which was eventually made on 8th of November? 8th of November. In my submission, the government does not have the power. This was realized way back in
Mr. Chindambaram, before that,
Yes.
if you can give some sequence of events to understand better.
All right, I'll tell you.
Just the sequence, what happened on what day, just a few,
Well, there are only 3 events to our knowledge, and none of the documents pertaining to those 3 events have been produced, which is one of my complaints, which I will address. According to the record, according to the counter affidavit, and according to what is available in the public domain,
Yes.
on the 7th of November 2016, government wrote a letter to the Reserve Bank of India asking for its recommendation whether 500 rupee note and 1000 rupee notes may be demonetized. The starting point, according to the record, is the letter from the government to the RBI. The RBI board, my lord, your lordship knows, consists.
What exactly is the query to the RBI? What exactly?
Please make a recommendation whether 500 rupee note and 1000 rupee notes may be declared as no longer legal tender.
That was
There is a letter from the government to the RBI. Much turns on that. On the 8th of November, the next day, the RBI did not take even 24 hours to consider the letter. The very next day, the RBI board meets in Delhi, not in Bombay. It meets in Delhi. The RBI board.
What is the significance? No, Bombay or Delhi. What is the significance?
Mr. Sharma, please maintain the decorum. Please maintain the decorum. No, please don't interrupt the proceedings like this.
Requesting that there will be one side only. I'm not saying anything. I'm saying only all the advocates.
You are interfering in the administration of justice.
They are extending church for nothing. And all the advocates, they are not only one advocate, they are all advocates are sitting and trying to see the court proceedings. They are helpless. Somebody should request them be one side, that I am requesting them to be one side. Nothing more than that.
Oh, please, just simply disturbing.
Then I should take the assistance of Mr. Sharma.
See, for your information, we can't see the attorney from here, for your information.
I'll keep standing, Your Lordship.
No.
On the screen we can see one.
On the screen. There is no screen on the other side? No.
There is a screen, but I don't know
Oh,
whether.
that is covered.
No, that side they have a smaller screen.
There is a small screen, yes. There is a screen here.
Anyway, they hear it's sufficient. They need not see faces. Okay.
All of you are hearing, no? The discussion, all of you are hearing. What will you do, old people, by seeing us? All 60 plus men. No, I don't know. Sorry, it was wrong.
Let the document.
What will you do by seeing us?
Now that
But everybody is
appetite
standing
is
over
whetted
here.
by television,
Everybody is
everybody
standing over
wants
here.
to see everything.
Okay. All right. Yes, Mr.
I want only the document to be made.
All right. Please take your seat.
Say all the advocate do is telling just for nothing. He should
All
sit in
right.
back.
Now you can hear, see,
The best,
this is,
I will wear a mask and that will be a good decoration.
oh, all of your VC links also.
Yes.
Of course, televised also.
Yes.
So that's
They can.
that explains why.
But when there is no.
I didn't want to say anything.
Can't be helped. Yes,
No, Mr. Attorney, it means
And this is not the first time a constitution bench is heard. This is always like this, in the court,
no, Mr. Attorney, according to you, even if Sharma goes out, he can see the proceedings.
Yes.
Yes,
He can see the proceedings wherever he is.
on the phone.
Otherwise, if he is interested in seeing,
Wanted to get the BC reading, Your Lordship. I declined and court martial say mention before the court. I'm not well. I'm not well.
All
I'm
right.
not well.
What you want VC link, is it? You want right now, we will provide. Please give.
Yeah. If BC link is there, I have no objection. I will sit in my home and
he is not well,
Please.
he tested.
court master declined. I give you my,
I can-
their reply to. I show my reply, Your Lordship, her reply.
Please give him the link, huh? Give him the link. Right now you give him the link. All right. It will be done right now. All right. Now you take your seat. Right. Yes, Mr. Chair.
On the 7th of November, the government writes to the RBI seeking its recommendation on whether 500 rupee note and 1000 rupee notes may be demonetized. On the 8th of November, less than 24 hours after the letter came, the RBI, which has its headquarters in Mumbai, its entire research staff, research department staff in Mumbai, does not meet in Mumbai, it meets in Delhi on the evening of 8th of November, according to information in the public domain. The RBI board, my lord, ought to consist of 10 independent directors under section 8(1)(c, but 7 slots were vacant on that day.
Please repeat. Out of
10 independent directors under 8(1)(c) of the RBI Act,
Yes.
only 3 were in place, 7 were vacant. They had not filled it.
All right.
They had not appointed independent directors.
All right.
So the RBI board effectively consisted of the governor, the deputy governors, 4 deputy governors, 4 officers of the central government nominated by the central government, and under 8(1)(d), 2 government officials nominated by the central government, are believed to have met in Delhi and passed a resolution recommending 500 rupee and 1000 rupee notes may be demonetized. This was on 8th of November. That resolution or recommendation.
This was the statutory obligation, right?
Well, actually, the statutory obligation is the reverse. On the recommendation of the RBI, the government may demonetize.
Okay.
Here, it started with the government writing a letter to the RBI. RBI recommendation is transmitted to the cabinet. According to the information in the public domain, the cabinet is already meeting and it's waiting in the cabinet room. This recommendation comes to the government and this recommendation is accepted, and within minutes of the recommendation being received by the government makes the notification of 8th of November. And the Prime Minister, Honorable Prime Minister, goes on television at about 8 p.m. to announce demonetization while his cabinet colleagues are waiting in the cabinet room. They were requested to wait in the cabinet room. Question is, my lord, my lady asked me a question. Is this the procedure contemplated in section 26? Assuming you're exercising your power bona fide under section 26, a matter so serious and so important as demonetization, which will effectively take away 86.4% of the currency, can it be decided in a matter of 24 hours? Between 7th November, when the letter is received by the RBI, the board meets in Delhi, it is transmitted to the cabinet, and cabinet instantaneously accepts it. What is the application of mine? Is this the procedure followed under 26? The first submission I'm making is this is a perverse reversal of the procedure. The suggestion should have emanated from the RBI with research, with facts, with figures, and the entire matter should have been placed before the RBI, and RBI board should have deliberated it and sent a detailed recommendation. Government should reflect on it, maybe a day, maybe two. Government should reflect on it and pass such an order. All this was done in 24 hours. Now, my lord, our allegation is...
Mr. Chindambaram,
yes.
I don't know, but all these things have to be done in a super secretive manner because it should not leak all these.
Of course you can do it. Of course you can do
what
it.
you said, it should be deliberated for long and all.
Board has to deliberate.
Huh?
Where did the board? Therefore, what we are asking is, the letter of 7th November is not placed on record. The agenda note for the board meeting is not placed on record. The actual resolution of the RBI recommending on 8th of November is not placed on record. We are now witnessing the Hamlet without the Prince of Denmark. Where is the 7th November letter of the government? Where is the agenda note for the board? Let us see what was disclosed in the agenda note. Did they disclose to the board that by demonetizing 500 rupee note and 1000 rupee note, 15,44,000 crore worth of currency will be withdrawn, which represents 86.4% of the total currency in circulation. There was this incorporated in the government, in the RBI recommendation. Did the cabinet know that 86.4% of the currency will be withdrawn? Well, I can't imagine responsible cabinet ministers approving something which withdraws 86.4% of the currency overnight. Therefore, let us have those. We don't have those documents. The counter does not disclose those documents. It's not attached. Therefore, my lord, the first question is this...
Out of that currency, 98 point, I think...
Only, my lord, 15,44,000 crore worth of currency was demonetized. 15 lakh, I'll tell you, give the exact number.
So what is not demonetized is, I think, between
15 lakh,
1 and 2%.
Yeah, about little fraction more than one. Just a moment, please. You want to answer one? Fraction more than 1% did not return. And in court number 1, the then Attorney General told Chief Justice Thakur's bench, we expect that 3 lakh crore will not be returned, and that will be extinguished from the liability side of the RBI's balance sheet. It will be taken as RBI's profit, and government will get a dividend on the profit. In fact, the entire profit will be transferred to the government. 3 lakh crore. Later, in later hearing, the number was increased to 4 lakh crore. Government will get a bonanza of 4 lakh crore. As my friend Shyam said, eventually only about 16,000 crore out of 15 lakh 44,000 crore was not returned. And that not returned could be the currency note has been destroyed, lost, washed away in flood, spoiled, or like him, he was abroad, he couldn't exchange it. 16,000 crore out of 15 lakh 44,000 crore. Effectively, my lord, every note was exchanged. And of the notes exchanged with the RBI, RBI's annual report says that only 0.0027% of individual currency notes were found to be fake notes. 0.0027% was found to be fake. Every note that had been returned had been accounted for by the RBI. The annual report is there. We will place all that. Therefore, Mullah, the first question is this the way a decision can be taken? Is this a reasonable, prudent decision-making process that you withdraw 86.4% of the currency in 24 hours and don't place those documents in the public domain? Milord, we have asked for these documents. These documents have never been placed in the public domain. 7th November, 8th November agenda note, and 8th November recommendation. That's the first question. The second question is, does Section 26 give you the power to do this kind of demonetization? If Section 26 gave you the power, then why in 1946 and 1978 did you have to pass a separate law?
Mr. Chindambaram, before going into the legalities, as you understand, because you are a man with great experience.
No, I don't think it.
Generally, what are the objects of this type of demonetization?
They have said three things. Well, look, the objects of demonetization are rather simple. That is 46 and 78. Currency notes not in use should be taken out of the system because it adds to the liability side on the balance sheet. Well, every currency note issued is a liability of the RBI. That's why your lordship will see that I promise to pay to the bearer of this note 100 rupees, the governor signs it. It's a liability side. If the liabilities keep mounting by unused or unusable or disused currency, the liability side keeps on increasing. So the liability is extinguished by demonetization. That is one object, which is a well-recognized object. The other situation in which demonetization is resorted to is when there is hyperinflation and your currency becomes worthless. For example, Milord, in some Latin American countries, they are issuing the currency, Argentina, earlier in Zimbabwe, the currency became worthless. Even a 100,000 rupee currency note could not buy you even a cup of coffee. It's completely worthless currency. You demonetize it. You demonetize it and replace it by new currency. That for every 100 rupee now we will give you a 100 rupee note. That is a legitimate objective because of external factors, domestic factors. Your currency has become practically worthless. You will now completely replenish the currency. That is the second objective. Well, these are the two objectives, as far as I know. Disused, unused, unusable currency to be taken out of the system and the balance sheet to be extinguished of the RBI. Second is worthless currency to be replaced by currency with worth. Well, the lordship
What
knows.
about black money and terror funding?
That is what they've now we come to that. They are saying fake currency, one, black money, and fake currency used for terror funding. These are the three objectives mentioned in the notification. We'll take your lordship through that. But the fake currency eventually turned out to be 0.0027.
Negligible.
I mean, infinitesimal, absolutely negligible. The second then one they said is, they added corruption later, but the notification only mentioned black money. Let's assume black money is the... Now, black money, we've got data, we trace that. Within weeks, days and weeks of this demonetization, Income Tax Department, TRI, seized unaccounted money in 2,000 rupee notes, the new 2,000 rupee notes. If I want to hold black money, nothing prevents me from storing it in 2,000 rupee note rather than 500 rupee note. Milord, the three purposes of currency are well known, Milord. Many of your lordships may have been economics graduates. Three purposes of currency is, one is store of value. The RBI says this paper has a value of 100 rupees, the store of value. Other is unit of account, because I have to maintain accounts. I need to know what is my income, what's my expenditure. I have to maintain accounts in some way. So I maintain account in currency by saying I have 1,000 rupees in cash, I have 10,000 rupees in a bank. And the third is medium of exchange. Before currency came, it was barter. Instead of bartering A for B, we now put a value, and that is the value, and the currency mediates the transaction between the giver and the taker. These are the three purposes of currency. Now take the first one, store of value. What they say is you are storing value in an unaccounted money in 500 and 1,000 rupee notes. Therefore, we're going to cancel them. If you had eventually achieved your objective of getting that currency cancelled, it is neither returned or if it's in your hand, after 30th of December, you can do nothing about it. It becomes a worthless piece of paper. But if you issue a 2,000 rupee note, in fact, it's easier for me to store value in a 2,000 rupee note than in a 500 and 1,000 rupee note. What I would require 4 500 rupee notes or 2 1,000 rupee notes, I'm storing my value in 2,000 rupee notes. So when the DRI and income tax conducted searches and raids, they found unaccounted money in 2,000 rupee notes. So whether that objective is achieved or not, they may have genuinely believed that the objective will be achieved. Then on fake currency, within weeks, and I'll give you the dates and places, in Bandipur, 2 terrorists were killed. And on them, on the bodies of the terrorists, they found 2,000 rupee notes. They also found fake currency. So fake currency, fake 2,000 rupee notes. And the third one, my lord, the fake 2,000 rupee notes started surfacing within months because technology is neutral, my lord. If the government can get the technology, the counterfeiter can also get the technology. So it is a different matter that according to us, none of the objectives were achieved, but that may be outside the purview of judicial review, whether the objective was achieved. The point I'm making is, in order to achieve these objectives, was this the method? Did you examine alternative methods? And I will cite the judgments of Justice Chandrachud and Justice Ramasubramanian for the benches, that you are obliged to examine alternative methods of dealing with it. And after examining the alternative methods, you can arrive at a method. Here, did the board examine it? Did the government examine it? Did the government spell out the various methods of dealing with this menace? Did the RBI board address it itself? According to us, nothing was there was no agenda note. We want to see the agenda note before the board. What was disclosed to the board? Well, according to my information, it was not disclosed to the board that by demonetizing 500 and 1,000 rupee notes, 86.4% of the currency will be withdrawn. Well, no prudent cabinet minister, no prudent board member will ever agree to 86.4% of the currency being withdrawn from circulation. Anyway, so the second question is, first was the procedure. Second is, does the Act give you the power? If this power was there, why do the 1946 Act and the 1978 Act, the second question, start with the word, notwithstanding anything contained in section 26, we are passing this law. Because in 46 and 78 at least, Parliament felt this power was not there in 26. This kind of demonetization, the power was not there in 26. And therefore, kindly see the 78 Act, Mother. Now kindly see the 1978 Act. Kindly see section 3. On the expiry of the 16th day of January, all high denomination banknotes shall, notwithstanding anything contained in section 26, cease to be legal tender. Why did they put the words notwithstanding anything contained in section 26? Similarly, my lord, the 1946 Act, section 3, on the expiry of 12th day of January, notwithstanding anything contained in section 26. Therefore, my lord, these are indications how Parliament viewed its power. Now you exercise the power under 26 without a parliamentary law, without a debate in parliament. If it's earlier, you had to find another legal peg on which to do demonetization, notwithstanding anything in 26. Can you access this? Does this power flow under 26? Our submission will be that this power is not available in 26. This power is not available. That is the second submission. The third main submission, my Lord, will be that the objectives that you set up were false objectives. These objectives could never be achieved by this kind of a notification. I agree, my Lord. The scope of judicial review on that ground will be limited, but we still, within the limited scope of judicial review, whether a government can set up false objectives and pass such a law. The fourth ground will be proportionality. ₹15,44,000 crore by value, equal to 86.4% of the currency in circulation, was withdrawn overnight, leading to horrendous consequences. Horrendous consequences.
You said 86.4%.
Yes. In terms of the value, 2,300 crore individual notes, discrete notes, 2,300 crore notes, 500 and 1,000, the 2,300 crore notes. By value, the value was 15,44,000 crore. And as a proportion of the total currency in circulation, it is 86.4%. That was withdrawn overnight. And the horrendous consequences, your lordships may have said, many families were simply without money. 11 crore people stood in a queue every day to change their money. District cooperative banks were not allowed to receive deposits or exchange notes. The entire farming community was completely at a loss. It was a sowing season, November, sowing season. They did not have money to buy fertilizer, seeds, or hire labor. Wholesale markets were shut down. Prices crashed. Now we have the data. Prices crashed. Weekly fairs in villages stopped. Retail outlets reported a calamitous drop in sales. Industrial hubs came to a halt. Wages were not paid. And casual labor, 33% of all employed persons, amounting to 15 crore, are casual labor, daily labor. They were without work or without income. And the promise they made that 24,000 crore will be allowed to be withdrawn was not honored. Was not honored. That's the Chief Justice Thakur's order records that and tells them you do your best. This kind of horrendous consequences, were they envisaged or contemplated by the RBI board or the government or the cabinet? Did they know these consequences will happen if you withdraw such a large amount from currency in circulation? So is it a proportional way? Is it a proportional measure to achieve even the objectives that you set out for yourself? That is the next. The next ground is arising out of 26.
Mr. Chindambaram, one question.
Yes.
Suppose instead of 86.4%, suppose if they had withdrawn 40%, what would have happened? You had this argument, you would have...
No, this argument of proportionality will be a weaker argument. I concede that. It will be a weaker argument. The argument will remain. Depends on what notes they withdraw. Well, my personal view is somebody did not even know what notes are largely in use. Somebody belonging to the ages thought that 5 rupee and 10 rupee and 20 rupee notes are the ones currently in use. That's not so. It changed long ago. The notes in circulation, which people use every day, the bulk, the overwhelming bulk was 500,000. Overwhelming proportion was 86.4 was 500,000. You don't withdraw 500,000. If you had, say, demonetized only the 1,000 rupee note, maybe the impact would have been much less. But if you demonetize 500,000, thinking that these are scarce notes, only very rich people have, it's completely wrong, Miller. Ordinary
2,000 rupee notes have not withdrawn.
2,000 were issued for the first time.
Issued.
Which leads to the next round.
Introduced.
Now, my lord.
See, the proportionality argument will have to be seen in the context of the justification for this policy.
Yes. And if
Every
the
time it
justification failed.
No, therefore, objectively, it has to be seen in the context of the justification.
Absolutely.
Not solely on its own basis.
Absolutely, Miller. Even if you're placing burden on the people, if by doing this drastic step, if you are achieving your objectives, they may defend it. But the objectives were not achieved. As I am pointing out to your lordship, 0.002% of the notes were found fake, and the black money shifted to 2,000 rupee notes. So the two objectives were not achieved. They added another objective.
They didn't do this when they banned this, only thereafter.
No, according to me, you should think through that is why there's a board. That is why section 26 says the board must recommend, not the government issues a command to the board. Will you recommend? And the board recommends within 24 hours. Well, let us see the agenda.
The experts should deliberate.
There is enormous research on demonetization. There is enormous research on the impact of black money. There is enormous research on faking. The most counterfeited note, I know, most counterfeited note in the world is the US $1. But they don't care. They say, we are the reserve currency. What does it matter whether somebody counterfeits the note or not? Eventually, you will deposit it in our banks. So we don't care. They don't take any action against the $1 note which is being counterfeited. If counterfeiting was such a serious problem, as my lady says, and you want to achieve it by demobilizing or demonetizing 86.4, then show that it has achieved the objective. No, the question really is not for your lordship to ask, if I may say with respect, did they achieve the objective? Did the RBI deliberate on this objective and then make a recommendation? Did the RBI deliberate on this objective and then make the recommendation? If you meet within less than 24 hours without an agenda note, without research papers, what would you have deliberated? And how is I ask myself, this may not be an entirely legal question. How is the cabinet waiting to receive the recommendation, and the recommendation is received and it immediately approves it? Should not the government deliberate? Should there not be a cabinet note based on the recommendation? I want to see the cabinet note. It should be placed before your lordship. Suppose there was a draft cabinet note, but how do you know what the recommendation will be? Suppose the recommendation was negative. Suppose the recommendation said you can only demonetize 1,000 rupee note and not 500 rupee note. You have to amend your cabinet note. Was the cabinet note amended? Well, nothing of that sort happened. So let them place these documents. Well, the other question that arises out of 26 is, if the 26 is conferring the power to demonetize up to 100%. Let's take an extreme case. Then should it not have some guidelines? Does 26 have any guideline? There is no guideline in 26. So you can demonetize 5%, you can demonetize even 99.9%. Where are the guidelines in 26? Therefore, we are challenging. We are saying read down 26. Read down 26 strictly to say only the government.
Let us read 26 first. Let us read 26.
Please read 26.
So can't it be argued that there is an inbuilt safeguard in 26 too? Because the power by the central government can be exercised only on the recommendation of the central government.
Correct. Precisely, that's my argument. The proposal must be initiated by the RBI. Please see 26.
Yes.
Now, what happens to a case with where the RBI does not initiate a proposal, then should the government keep quiet?
No, RBI can initiate, because our government has, kindly see the section, composition of the
On
board.
the
in Section 8.
recommendation.
Section 8. Section 8, the government has its directors there. 8.1b and 8.1d are government directors. 8.1b, 4 directors to be nominated by the central government. And then 8.1d, 2 government officials to be nominated by the central government. The Secretary Economic Affairs is nominated under 8.1d on the board.
But no recommendation comes from the RBI, then what happens?
No
The
recommendation.
government
Then
hold
they
its
should-
hands and keep quiet?
No, it does not have to hold that. It must ask its directors to place it on the RBI board agenda, have a discussion, let the government, the RBI board take a decision. That decision must be transmitted to the government. Then the government at the highest level will call the governor and discuss, listen, this is what we want to do, and this is what your decision of the board is. Please reconsider your decision. See, it's not, government is not helpless, my lord. After all, the governor is not appointed by the RBI. The deputy governors are appointed by the RBI. They are not, my lord, completely alien to the thinking of the government or the needs of the government. But it must be discussed first in the RBI board before a proposal is initiated. Here a command, virtual command comes and you pass a resolution in 24 hours. You know, at some time, some stage, your lordship has to look into these documents. Now look at 26. My lord, Justice Nazeer asked, please look at 26.
Yes.
On recommendation of the central board, by notification, declare that with effect from such date as may be specified, any series of bank notes of any denomination shall cease to be legal tender. Now, if you have the power under 26(2) to declare nearly 100% of currency in circulation as illegal tender, no longer legal tender, should not Parliament have built some guidelines and some principles shall have regard to or shall not have regard to? Some guideline should be there. So this section ought to be read down. And I'll tell you, Lordship, what we will argue should be read down. It should be read down to mean any series of banknotes means, and that's how they understood it in 46 and 78, 1946 and 1978. Any series of banknotes means of any denomination, not all series of the same denomination. Any means any series, not all. Normally, any includes all. But if you read any as all, where we have now the Mahatma Gandhi new series. Earlier, we had the Mahatma Gandhi series. Earlier, we had the King George, whatever series. Any series is read as all series of banknotes of 500 and 1,000 denomination. If you read it that way, then this is an extraordinary power without guidelines. So any series must be read as any particular series of banknotes of that denomination. That's a submission. We will develop it. That is why, since they wanted to demonetize all series whenever issued of 10,000 and 5,000, they had to pass a separate law. So if you wanted to demonetize all series of 500 and 1,000, you should have had a separate law. And Parliament should have debated it. You can't invoke 26(2). With 26(2), if you invoke and that power is there, please don't interpret 26(2) to convey that power. Who knows, Miller? Today the government has done 86. Who knows? Another government.
Chindambaram, are you suggesting there is no law at all for demonetization?
There is
As of now.
There is no 26(2) ought to be read down. 26(2) does not give the power to demonetize all the series of one denomination.
No, there is one problem, Mr. Shah.
Please.
See, section 26(2).
Yes.
First of all, we have our own doubts whether we can really call it a case of demonetization, because if you carefully read 26(2), it says, on recommendation of the central board, the central government may by notification of the Gazette of India declare that so and so shall cease to be legal tender,
Yes.
not at all places and not at all times, save at such office or agency of the bank and to such extent as may be specified in the notification. Therefore, this case is not exactly a case of total demonetization as it happened in the case of 1946 and 1978.
No, well, it's exactly the same. They also exchange the notes.
The notification at page 33 of the compilation given by Mr. Divan,
Yes,
it says the notes can be exchanged.
yes,
Windows are open
yes.
at such places and to such extent.
But the same thing was done in the 1946 and 78
That was
by the Act itself.
by the Act itself.
Yes.
Therefore, here the power of the RBI is regulated to say that you can declare it as no legal tender,
Except,
save at such office and to some extent.
but the same thing was done in 46 and 78.
That's right.
Section 7.
In fact, they could have done that and when they are doing it under parliamentary enactment, they could have done it totally.
Yes. No, but they did not.
That's right.
They did the same kind of demonetization. Demonetized the specified notes, but gave a window for exchange. Both in 46 and
That
7.
was provided by the Act itself. Here, when you talk of the lack of power of the RBI, on the ground that there are no guidelines, the provision itself says you have a limited power to say that you cease to be a legal tender, save at such office and to such extent. So these are the two guiding factors for us.
That is an absolute discretion of the RBI. Look, there's no guidelines for that. This is our complaint. If you had passed a separate law where you demonetize a particular denomination and provide a window for exchange of notes, and that is debated in Parliament, and Parliament passes the law, there has been an application of mind to what extent you will demonetize and to what extent you will provide for an exchange. So that is why a separate law was felt necessary in 46 and 78. If you can do that under 26(2), why did they have to have a separate law?
At the time of 1946 Act, this amendment save at such office and to such extent was.
No, Malad, that was the same language. Look at the footnote, Malad. It's just slight change in language. Look at 3, save at an office or agency of the bank. So that saving was always there.
To such extent was.
Such extent was not there, but the saving provision, they could have done it to a large extent or a small extent.
Not a case of complete lack of power.
Anyway, my lord, in 1978, this amendment had already come. The saved and to the extent has come. My lord, Parliament thought, and according to me rightly, that 26(2) does not give you this power. This power in 26(2) is to only demonetize a particular series of notes of a denomination, not all series of a denomination.
But it is by a notification in the Gazette of India.
That is the saving part. Notification of the Gazette of India. By notification, you will specify the note
Yes.
on the recommendation of the RBI. But the power is the power to notify all series of a denomination or any particular series of a denomination. Our submission will be, for your lordship's consideration, it is only a particular series of a denomination, not all series of a denomination.
But it is not necessary that there should be a legislation for it.
Well,
Because here it says by notification in the
if
Gazette.
you want to demonetize all series of a denomination, and if 26(2) does not give you the power, in my way of looking at it.
As may be specified in the notification, any series of banknotes of any denomination. What do you mean by that?
That means, according to me, must read it to me, any particular series of banknotes of any denomination. Not all series of notes of 500 denominations.
No,
Any particular series, suppose a series was issued in 1950 and you want to demonetize it, you can demonetize. But you can't demonetize notes were issued day before yesterday. They demonetized notes issued even the previous week. You know, the printing presses print 300 crore notes a month, which is roughly about 10 crore notes a day. It works round the clock. So even yesterday notes were issued, that is demonetized. in 500 and 1000. Does that power there, your lordship will have interpreted, if 26.2 gives you that power, according to me, it does not give you the power. If your lordship interprets it to mean any means all series, then I would argue then there are no guidelines when you can demonetize all series of a denomination. You must have some guidelines for that.
That depends on the economic wisdom, the wisdom of the powers that be,
Oh, my lord.
and the situation as it develops.
Precisely.
There may be a financial emergency. There may be cases
Precisely.
where the government
Precisely.
have to
Guidelines,
act.
Parliament then should say, shall have regard to 1, 2, 3, 4. The economic situation of the country, financial emergency declared, the proportion of currency that will be withdrawn. Look, that is the most important part of demonetization. What is the proposal? Suppose the guideline said, however, shall not withdraw more than 50% of the currency in circulation at any given time. That's a guideline. Here you have no guideline, you can withdraw 100% of the currency in circulation, which is why, my lord, they thought in 46 and 78, this does not give me the power to declare all series of 10,000 rupee note as no longer legal tender. I have to pass a separate law. Now, please see the denominations that were demonetized in 46 and 78.
Just 1 second.
Please, my lord.
They were withdrawn true under section 26.
Yes.
And you had the liberty to exchange. Maybe there was some hardship, we understand, but you had the liberty to immediately exchange. Maybe there are some hardship. Of course, you have to stand in queue and all. We understand that is in practice, but on testing your argument.
My lord,
Testing your argument. That's all.
my lord, no demonetization is not followed by remonetization. Otherwise, the country will come to a grinding halt. So demonetization as
Yes.
demonetization is always followed by remonetization.
Remonetization.
That remonetization. Because otherwise the country will come to a halt, my lord.
If that is so, there were some hardship, all of
No,
the
I'm answering that. Now, when you 46 and 78, when you demonetized 10,000 rupee notes and 5,000 rupee notes, there was a very small proportion. Even then, they provided for exchange. Even that note was exchanged. A very small proportion of notes was withdrawn, but they had a window for exchange within a particular time. There was no need to do any massive remonetization because the other currency notes were in circulation, 1,500, 150. Today, you've withdrawn 86.4%. At least you know now you've withdrawn 86.4%. You should remonetize it. You should have equivalent currency notes so that it can be exchanged. They did not have 1,000 rupee notes because they did not print 1,000 rupee notes. They said, in fact, they passed an order discontinuing 1,000 rupee notes under section 24. So no 1,000 rupee notes. Even today, there are no 1,000 rupee notes. They only remonetized through 500 rupee note and 2,000 rupee notes. We will show the numbers. The 2,000 rupee notes were alone printed in the first phase. 500 rupee note was printed later. Unfortunately, two things happened in the 2,000 rupee note. The ATMs had been calibrated to receive only 50, 100, 500 and 1,000. ATMs were not calibrated to receive or stack or dispense 2,000 rupee notes. So the entire ATMs had to be recalibrated. And I have the numbers of the number of ATMs in the country which had to be recalibrated. That took more than a month, number one. Secondly, my lord, the 500 rupee notes, as I told your lordship, 300 crore is the capacity of the printing press. Discrete notes, 300 crore notes. You have withdrawn 2,300 crore notes. Simple arithmetic tells you, even for note, if you were substituting, it will take you 7 months to remonetize so that the currency will be available for somebody who will exchange, which is why nobody could exchange it. They were, apart from the legal limit of exchange, there was a practical limit of exchange. The shutter will come down in 2 hours. Your lordship saw the visuals on television. The bank officer will come at 11 o'clock and say, no more currency notes today, come tomorrow. Because they did not have enough currency. Remonetization took several months. And then they recalibrated the ATMs. Apart from this, there's other practical difficulty. What is the geographical distribution of the bank branches and what is the geographical distribution of the ATMs? I will place the numbers before your lordship. The geographical distribution in a state like Tamil Nadu or Karnataka, you can access a bank branch within 3 kilometers, maybe 4 kilometers. In Bihar and in the Northeast, it's 12 kilometers and 15 kilometers to access a brick and mortar bank branch. And the ATMs, I will place the numbers state-wise what the ATMs were at that time. There were hardly any ATMs in the Northeast. They had to trek 13, 14 kilometers to exchange their money. Therefore, Miller, all this I'm asking is part of the decision-making process. Did you apply your mind? Let us see the agenda note, Miller. Let us see the resolution. Therefore, the way to read it is 26.2 does not give you the power for wholesale demonetization. It only gives my submission. Lordship, consider. My submission is it gives you the power only to demonetize any particular series of denomination. If you wanted to do all series of a denomination, Miller, denomination is the 500 and 1,000. Series is, your lordship will take a currency note. It has a letter and then a number. That is the series. And it's called now it's called Mahatma Gandhi New Series. The earlier note was, this is the Mahatma Gandhi New Series, 9MS574043. This is the series by which it is issued. If you demonetize all the currency notes issued ever since currency notes started in 500, does that power flow from 26.2? If that power flows from 26.2, I'm saying it is unconstitutional because it violates Article 14. There are no guidelines. So either read it down or strike it down. And there's a way to read it down. Read it down to mean any series, mean any particular series. If you want to do all series of a denomination, pass a separate law, like in 46 and 78. Well, 46 at least is pre-constitution, but 78 is post-constitution. Article 14, Article 13 will apply. So the 26(2), if it is read that way, it has to be struck down as all series of a denomination. Well, I would humbly request that the government should not have the power under 26(2) to declare all series of a denomination as no longer legal tender. That will be a drastic power, drastic power. Therefore, read it down. But if you don't want to read it, I mean, if the government wants to still, let's pass a separate law. The separate law will be debated and they will decide whether such a law should be passed or not. It's a different matter. So the validity of that law can also be challenged, but at least a separate law where the government comes forward and says, I am demonetizing all the series of 10,000 rupee notes, all the series whenever it was issued, 50, 60, 70 or 5,000 rupee notes. But here you demonetize the note issued the previous day. Why did you issue the note on the 7th of November and demonetize on the 8th of November? What purpose? Why did you issue the note in the first place? And this is note issue, 500 rupee note came several years ago. All the series have been demonetized. This is the alternative submission. This power is not available in 26(2). If the power is available, we are challenging the section as unguided, uncanalized power and violative of Article 4. Well, the next broad ground is that did you actually declare any note as illegal tender? Proof of the pudding is the eating. Governor says, and I quote, the withdrawal of legal tender status did not extinguish any of RBI's balance sheet liabilities. So which means all the notes came back. So the liability still...
Before you go into that question,
Yes.
before that legal,
Yeah.
one query, Mr.
Please,
Member. Now, all right, they have demonetized 86% so and so. Now, under which law this exchange is permitted? They have not, it is not a loss to you as such. It is not a loss, as we said earlier. There was, you could have exchanged it.
Yes, I'm not denying that.
If you test from this angle, how do you say it is bad?
Miller,
Please tell us.
I say it is bad. Some individuals suffered monetary loss. Shyam Divan's client. Because if you don't exchange that 1,62,000,
That we can always set right. That's all right. On a legal.
No. Therefore, there could be cases where persons actually suffered a monetary loss. But the vast majority of the people, if they were able to exchange the note within the window provided, there was no monetary loss. I concede that.
Yes.
There was no monetary loss.
There is no monetary loss. Then what?
There was no monetary loss.
Follows.
But what about the non-monetary hardships? People lost their wages. People lost their income. Families went without meals. They could not buy medicines. 100 people died in the queues. Over the period of time where people standing in queues, 100 people died in queues. Therefore, the non-monetary loss, we say you should have contemplated all this and applied your mind and taken into account all this before you did all series of 500, all series of 1,000. There's no monetary loss for the bulk of the people. But if I lost my job, if the small unit closed down, several units closed down, if prices crashed, I can show you the prices in the wholesale market on the 7th of November and 1 week later. Prices of all farm products crash. And therefore, if I bring it to the market on that day and I sell it at a lower price, I suffer a monetary loss. What about the fruit vendor, flower seller who doesn't sell for several days? There is a monetary loss. There is no monetary loss in the sense that note for note, there is no loss. But there is a monetary loss in the sense that I've lost my job, I've lost my income, I've lost my wages. I can't buy fertilizer in time. I can't buy seeds in time. I can't hire.
So according to you, what should they have done?
What they should have done is they should have only demonetized specific series of 500 rupee notes and 1000 rupee notes, not the note issued the previous day. If they wanted to demonetize the entire one, they should have kept exchange notes ready, enough notes ready, so that remonetization will take place in 1 week. In fact, the finance minister, then finance minister, made a public statement. All your worries will be over by 15th of November. It's there in the record, 15th of November. He gave himself 1 week.
But
You should have had cash ready, so that the moment a person's note is demonetized, he can go and exchange it. So your ATM was not in a position to dispense the notes, Miller.
no, we understand this hardship faced by the common man. But when we are testing the hardship, can it have a bearing on the constitutional validity of the action?
On proportional. Hardship
is
for the purpose of proportionality to decide.
consequence of a legislation would cause hardship to a section of the people, and no doubt here almost the entire populace was affected. But can that have a bearing on the constitutional validity of the
Not
action?
directly. Hardship will be taken into account to decide proportionality of this measure. Your Lordship, I'll read the judgments on proportionality. Proportionality, your Lordships have a livelihood has to be a factor taken into account. Article 21. Now, people have lost jobs, lost incomes. Therefore, my Lord, proportionality, you should have been prepared. If my Lord Justice Nazeer rightly says, if I may say with respect, note for note you exchange it. Aladdin, Miller, new lamps for old, new notes for old. You exchange it immediately, there's no problem. You didn't exchange it, no? You did not exchange it, you were unprepared. You did not even know how many notes you required. Your capacity of the printing press is 300 crore notes. You have demonetized 2,300 crore note. Simple arithmetic will tell you it will take you 8 months. Did you print enough currency and kept it in reserve before you demonetized? Therefore, proportionality. Did they apply? Well, the most important thing is, was a decision taken rationally after considering all the facts? Let us see the documents, Miller. We are arguing, Miller, blind.
The language employed is 26(2) is on the recommendation of the RBI.
Correct.
So while making the recommendation, they did not apply the amendment for all these consequences. Yes. This is what you are suggesting.
Yes. And the counter says, government advised the RBI to make a recommendation. The word used is advised.
But the initiation should be by the RBI.
That is our submission. Initiation can only be with the RBI. If the government wants to put its point of view to the RBI, it can do so in the board. It has 6 people on the board. You start it in the RBI. You ask your nominee to the Secretary Economic Affairs to go and tell the RBI board, listen, we have to consider demonetization for the following reasons. Let there be a research paper. Let there be a agenda paper. Let the board decide. And then you make a recommendation. You advise on the 7th of November evening and the 8th of November. The word used in paragraph 32. The Government of India, therefore, on 7/11/2016, advised the Reserve Bank that to mitigate the triple problems of counterfeiting, terrorist financing, and black money, the Central Board of the Reserve Bank may consider withdrawal of the legal tender status of 500 and 1,000. So what are you advising the RBI? RBI is the monetary authority, the only authority which can issue. Then the Central Board of the Reserve Bank, 33, met on 8/11 to consider the government's advice. It is not even a request, Miller.
It should be other way around.
It should be the other way around. RBI must advise the government, not government advising the RBI. That is how the problems arisen, Miller. My ladies' questions would have all been answered if they had a comprehensive agenda paper spelling out all the pros and cons of demonetization, spelling out these numbers, how many notes will be affected, what proportion by value, what proportion by discrete note, what is our capacity of our printing presses, how long will it take to remonetize, how will we exchange it, are our ATMs ready, are our bank branches ready, What about places where there are no branches, there are no ATMs? All this should be considered. Nothing was considered according to me. Nothing was considered. No, let them satisfy your lordship. All this was considered. They don't produce, the three documents must be called for at some stage. 711, 811, the agenda paper and the 811. These must come before your lordship. Your lordship is the highest court in the country. If you don't look at 711, the agenda paper and 811, then who will look into it, my lord? They are not showing it to Parliament. They have not placed it before Parliament. They have not placed it in the public domain. At least to the Supreme Court, they should show these papers and documents. Therefore, my lord, there are serious issues to be argued. Clearly, my lord, we can't be stopped at the threshold.
All right, we will continue at 2 o'clock.
Very well.
But they also know the law relating to adverse inference. Yes, Mr.
But may it please your lordship. My lord, summarize, I have submitted 7 heads under which we will make our submissions. I think your lordships have already noted it. But just for my benefit, my lord, I'm just reading the 7 heads on which we will make our submissions, submit material and case law.
You have prepared some brief note or something like that?
I will give it in writing, my lord.
Yes.
I will give it in writing.
Yes.
I'll read it quickly, my lord. It'll take 3-4 minutes.
Yes.
1. Section 26(2) does not allow declaring as no longer legal tender all series of a particular denomination. It must be read down to mean a specific series of notes of a denomination. Any series means any particular series, not all series. That is ground 1. 2. If not read down, Section 26(2) confers an unguided, uncanalized power and is liable to be struck down under Article 14 and 19 of the Constitution. Lives of humans and livelihoods of millions were lost or affected. Therefore, if you don't read down 26(2), then we will say this is an uncanalized power. 3. The decision-making process in the present case was deeply flawed. The role of RBI and the government have been reversed. Whether your lordships have repeatedly held, decision cannot be challenged, but the decision-making process can be challenged. 4. The recommendation of the RBI was for note exchange. Your lordship will see, effectively it was a note for note exchange. It is deeply flawed because RBI did not consider relevant factors and eschew the irrelevant factors in making the recommendation. I've given a number of relevant factors. One immediate relevant factor is what is the capacity of your printing presses in terms of the number of notes that you will demonetize. So you should consider relevant factors and eschew irrelevant factors. If you don't do that, then your recommendation is flawed. 5. The objectives stated by the government in the notification dated 8/11 were false objectives and could not be achieved and were in fact not achieved by the impugned demonetization. 6. Applying the test of...
Please read this one. Just
the objectives stated by the government in the notification.
Yeah.
Fake currency and black money. Those are the only 2 objectives. 8/11 were false objectives and could not be achieved and were in fact not achieved by the impugned demonetization. Because we found fake currency in 2,000 rupee notes springing up, and we also found a DRI and income tax recovering large quantities of unaccounted money in 2,000 rupee notes. So it was not achieved. You thought you will eliminate black money or at least completely or nearly suppress black money and nearly eliminate fake currency. Fake currency, the result is, according to RBI's annual report, 47 crore of fake currency.
Actually, about fake currency, we were discussing when we went,
Yes.
All fake currency holders won't come forward. Otherwise, they will be caught. No. Why would they come?
But in fact, they came, Malad. 99% came back.
No.
that was not a fake currency.
0.00227%.
Yes.
The fake currency exchanged with the banks was 0.0027%.
Something. Yes.
Yes,
I gave that number. Yeah.
So others who had fake currency were not dare enough to come to the bank to exchange it.
No, if the others had not come, to that extent, the RBI will report, I issued 15,44,000 crore by value of notes. I got back only so much, but they got back 99%.
No. Fake currencies did not come back. That means they were eliminated from the system. Normally how fake currencies get circulated, fake currencies are taken to some shops, malls, etc. Something is bought. So that's how it's put into circulation. But if that circulation, the curtain was drawn and they did not go to the bank to exchange it. To that extent, it went out of circulation, is it not?
No, we have great respect. No, it doesn't work that way practically. Milord, currency in circulation is legal currency issued by the RBI. Fake currency is not in the count.
Correct.
15,44,000 crore is what was legally issued by the RBI over a period of time, 500 and 1,000. Fake currency is not in that 15,44,000.
Correct.
It is extra.
Correct.
Whatever fake currency, maybe 1,000 crore, maybe 2,000 crore, whatever. So the fake currency is separate from the legal currency. So nobody knows how much the fake currency is because the RBI printing presses don't print.
People who had fake currency
people
in the
who had
denomination of 500 and 1,000.
Yes, we are only talking about 500 and 1,000.
They lost their ability to pass it off. Correct?
They passed on 47 crore. It came back. 47 crore was detected by the RBI as fake currency, which I did not issue. I'm RBI. 47 crore was returned to me and exchanged by some bank branch, either by ignorance or by oversight. And I detected 47 crore of fake currency. So as far as the RBI is concerned, it has extinguished 47 crore of fake currency.
No, it exchanged. What it exchanged was not what was presented to RBI, but what was exchanged was presented to RBI. Therefore, fake currency became a valid legal tender by exchange. The 0.0027% became legally valid tender, which otherwise it was not.
No, with great respect, your Lordship will pardon me for repeating it. As far as the RBI is concerned, this 47 crore was not, let's assume 47 crore, I give the exact number. 47 crore was not issued by the RBI under the signature of the governor, under the legitimate signature of the governor. It is a fake currency. It was printed in some spurious printing press. In my accounts, I'm showing liability, RBI. The RBI's accounts shows a liability of 15,44,000 crore. But some bank branch, some bank officer, out of ignorance, let's assume ignorance, exchanged 47 crore of fake currency for legal currency, new currency. So the guy benefited. The guy who exchanged fake currency profited 47 crore. But when the RBI gets the 47 crore, it will shred it because it's a fake currency. It will destroy it. So the 47 crore in the system, 47 crore of fake currency in the system has been seized and destroyed by the RBI or government. The remaining fake currency remains fake currency. So how did you achieve the objective of eliminating fake currency?
It becomes unexchangeable. If it was in denomination of 500 and 1,000,
yes,
it is demonetization. There is no way
it is unexchangeable, not necessarily untradeable. Some shopkeeper, some flower seller, some vegetable vendor.
They will not take that 500 and 1,000 after demonetization.
That is so, my lord. That is so. They will not accept the 500 crore after the 30th of after the 30th. But to that extent, we don't know whether that fake currency became a useless piece of paper. That's what my lord is saying.
That's right.
That it does become a useless piece of paper until he started counterfeiting the 2,000 rupee notes, which he started very shortly. That I admit. But nobody knows how much that is. Nobody found out that how much that is. That is there in the system. It may be used as a rubbish paper, raddi or whatever. It may be, but I agree that part I agree. It is in the system, but nobody got a value for that. Nobody could get a value. But your entire objective, well, there is a proverb in Hindi. What is it? Nikhil Oda? Should move a mountain and catch a Nikhil.
वो खोदा पहाड़ निकला चूहा.
You move a mountain to catch the fake currency. You only count 47 crore.
I don't understand Hindi, therefore, no.
I don't either. The translation is, the corresponding Tamil is, Malaye Killi Eliye Pidikkirathu. You move a mountain.
There, the objective was only to catch the rat, not the mountain.
Anyway, this is the submission that this note for note exchange did not actually achieve your objectives from the annual report of the RBI.
Did it not have any good effect on unaccountable or black money?
But they seized black money in 2,000 rupee notes. I'll give the data.
That was one of the objectives also.
One of the two objectives was
or
black money and fake currency.
Yes.
Fake currency continued to be printed in 2,000 rupee notes. And once they, to answer my lord's question, once they reintroduce the 500 rupee note, that old fake currency can be exchanged. Because there's now a 500 rupee note. The 1,000 rupee becomes piece of paper. I agree. But the 500 can be exchanged. Therefore, you didn't achieve that objective. To answer my lady's question, yes, they froze the black money for a while. I'm not denying that because people would have been afraid. But then very soon, the storage value, currency is first is storage of value. It shifted. Instead of storing my black money in 500 and 1,000, I started storing it in 2,000. And they seized 2,000. DRI and Income Tax Department seized 2,000. Anyway, this is not the main ground. All I'm trying to say is these objectives could never be achieved once you said a note-for-note exchange. If you had simply stopped by saying illegal tender, full stop, whatever the loss, whatever the consequences, and then of course these objectives will be achieved. And you only issue then 200 rupee notes and completely different denomination. No more 500 and 1,000, these objectives could have been achieved. But once you said note for note exchange, these objectives could never be achieved and in fact were not achieved. This was pointed out that once you say note for note exchange, these objectives can never be achieved. It can be achieved if you had started issuing 300 rupee notes and 600 rupee notes. It could have been achieved. But you started issuing 500 again and 2,000.
Earlier, there was a special bearer bonds. You see. That was also one of the experiments.
That is another scandal, Miller, the special bearer.
It's all for the same objective to see that black money is
Correct.
rooted out of the system.
Now, Miller, then the 6 is applying the test of proportionality. The so-called recommendation of the RBI and the decision of the government deserves to be declared illegal because lives of hundreds were lost and livelihoods of millions were affected. And we will give the data about the enormous hardship. 7, despite the passage of time, this honorable court can grant declaratory relief and mold the reliefs. Well, there is a number of judgments which say, despite the passage of time, you can grant a declaratory relief, lay down the law, and mold the reliefs. These are the 7 heads, my lord, in which I will address your lordship. I will type it out and submit it to the court master. The only 2 things that remain is, as far as I know, subject to correction by my learned friends on the other side, the Union of India has filed one affidavit, counter affidavit, in V.N. Sharma's case, which I assume is a counter affidavit in all the cases. The RBI has filed an affidavit, which I will take as a counter affidavit, in Adil Alvi's case, which I'll assume is the counter affidavit in all the cases, because they have not filed in individual cases. If this is the only 2 counter affidavits, then we will, lordships, subject to whatever your lordships may say, we will proceed on the basis that these are the 2 pleadings on that side. Unless they want to file something more comprehensive.
Yes, who appears for the union? Your pleadings are complete. Can we take that pleadings are complete in this case?
I may have to apply my mind here. As far as I'm told, there are 2
Because
counts.
there may be some factual problems also in some of the cases.
I'll take stock of all of them. If need be, we'll try to respond to whatever is minimally required. I'll try to come back. I don't want to open up.
There is not even notice, Lord, in the new series of matters which came after the legislation. They were just tagged. Now this, as far as
your notice has not been issued.
not even noticed.
So that is the latter set of cases.
Yes, that's
First set notice was issued.
Yes.
So the orders were passed by.
But the most important is after that legislation, no notice should have been issued because virus must have been challenged.
No, the arguments were filed, notices were issued. Then we were told that no more writs are being closed and file intervention applications. So whatever is to be served, we will serve on them. Obviously, when this court is saying don't file anymore, first they said
Anyway,
file writs here.
the intervention application itself is some
Yes, we have
writ
filed.
petition grounds.
That's right.
Well, if they wish to file a more comprehensive affidavit, I have no objection. But absent such an affidavit, I'm taking these two pleadings over.
Yes, you have to, I think somebody should take serious note of this from your side.
We'll do that. I will. Because there are whole range of implement applications.
That's all right, because this court asked them not to file the writs, filed intervention application. That itself is a pleading in a way.
But I don't find any pleadings which I think, except in one or two cases, the pleadings seem to be more or less the same. I need to look at those cases where the pleadings are distinct. We'll take stock of that.
Somebody should sit and sort out all these things from your side.
Let me try to get a feel on my feet in this matter.
If I may suggest,
But Millard, it's the fact that Millard, matters were tagged without notice being issued.
Well, regardless of the matters that were tagged, on the matters on which notice was issued, let my learned friends reflect and tell your lordships, these are the two pleadings, or we are going to file one more affidavit. I have no objection. If they want to file an affidavit.
Some of the arguments.
All cases put to, we will direct notice right now, that's not a problem. At least in one case, both of you, RBI and government should file a comprehensive,
We will do that.
treat it
We will
as
do
a
that.
pleading in all cases.
We
Will take it as a counter in all.
I'll be obliged.
We'll do that. It's a consolidated response to the entire.
And the last point,
Some of the arguments now being advanced, I think they are not part of the pleadings in many cases. Therefore.
no, it will be in one of the cases or other. Anyway, these are legal arguments. The last submission which we should make.
Reference to at 26
If necessary, we will file an application to summon these documents. But in a matter of this nature, the government should fairly place these documents before the court.
It should be with the RBI perhaps.
No, RBI and government, 711, both have got the documents. 711, 811 agenda paper, because the government director is sitting on the RBI board, Miller. Secretary Economic Affairs is sitting there. He will have the agenda paper. 711, 811 agenda paper and 811 recommendation. These three documents, your lordships may kindly consider directing them to place it.
if and when necessary.
Mr. Attorney, we want to see.
Your lordship will see that, but let me also look into that and find out whether they would advance the cost of all these arguments.
You can't keep it away from us.
Certainly not. Certainly not.
Well, those are my submissions, Millard, and I will rest now. Whenever your lordship fixes it, we will argue, and I won't take too long, Millard. I'll just elaborate on this.
This is all these 7 points, no?
7 points. I'll give a note on the 7 points.
But you also know where exactly you stand now. You can concentrate on these 7
Sure, Lord.
points, and also you can file a comprehensive.
We will do that. We'll sit together and put our heads together and file.
Even Gupta can.
Yes.
And keep those files. Perhaps you have to keep those files with you.
We may have some arguments to be advanced in respect of those issues also.
They can argue at any length, but eventually they'll show the files to your lordship.
The sheet anchor is 26-2, right?
There are certain arguments which are purely legal, constitutional. There are other arguments which are political.
On the recommendation of the central government. So where is the recommendation of the central government?
We'll come back.
Thereafter, where is the consideration by the RBI? And what was your reply? These are the 3 things.
One of my arguments.
This is on facts.
Correct.
Secondly, any series of banknotes of any denomination, how to interpret this?
Yes.
So Chindambaram says, read it down, or in the alternative, quash it. These are the.
Yes.
This is the sum and substance.
I have my thought process developed during listening to the argument. Something will definitely be of assistance to the court, but on a matter like this, you're not looking at 26 as any other statutory provision. It's in the context of whole economic banking system. It occupies a very important place.
That you must file your counter, sir. You must state 1, 2, 3, 4, 5.
We will do that. We will do
That's how we should dream, is it? Your stand.
We will do that because in the arguments are raised now, I am trying to respond.
They must have raised it in their pleadings, sir.
Not all of them. Not all of them.
One is sufficient for the writ petition, these grounds.
Not even one comprehensive, not one. While
All on facts. Everything is on facts.
You put all together and make it.
Now we know, Millard. Now we know how to put it.
That is why, my lord, I welcome a comprehensive affidavit from either of them.
That's fine.
I think you should, Parag, you should.
No, we welcome that. That's not the problem.
Ultimately, the pleadings get crystallized to the argument.
Yes.
Even if Ram says next. It's not available.
Whenever your lordship.
Next week, you fix a date after this
After
Deepavali, whatever date.
As early as possible, you know.
Take immediately a date, whatever.
19.
Ah.
No.
They are ready to extend my lord.
Remember.
Asha, you do one thing, that notice in all, wherever notice is not issued notice, please serve copies on the other side.
Yes.
Please, sir, all of you who have not served, please, sir,
Yes.
issue notice. Then shall we record, Mr. Attorney, that you will file a comprehensive
Your
report?
Lordship, please, sir. We'll do that.
And both respondent, Union of India, and RBI, Reserve Bank of India, Learned Counsel for so and so, seek time to file comprehensive affidavit.
Not one Miller, there are two also.
Hmm?
Not one Miller, there are two affidavits, one from us, one from
Yes,
them.
affidavits.
Because Miller, the.
All right, their respective affidavits, all
Their
right.
respective.
All right. List it on what date, Chindambaram, what date you want.
November 3, my lord.
Around the third week of November.
3 is
Just let us,
or
Wednesday.
2 is a Wednesday.
let us see the calendar.
The first,
Whatever date your lordship takes.
November. Thursday, I think. Break ಆಗ.
Except 1st November, my lord. Any date after.
Second.
Let it go beyond the 15th of November. I need to consolidate all these things, have a lot of deliberations on this. It's not a mere factual statement of an affidavit. It has a very important consequences. I need a little time to get back.
15th we have put on.
It has been pending for a very long time, Lord.
9th and 10th.
On 15th, we have listed the other matters. 15th November.
Everything.
Start on 9th.
Your Lordship have it.
9th is all right.
Very well.
That's a week.
8th is a holiday. 8th is a holiday.
9th.
Nice.
9th.
Would it be fine if Your Lordship have it on the 15th?
No, we will start on 9th.
9th.
Now we know what exactly it is,
No, we can always refresh Your Lordship.
Now we have understood what it is.
9th November.
9th.
Obliged.
Well, so obviously the notice.
If the lordships don't have a problem, Miller, 10. Instead of 9th, Miller.
Let it start on 9th because
Let us start on the
Wednesday.
9th.
If it spills more, then it will go on Thursday.
Yeah.
10th is a Thursday, my lord. Let us start on 9th.
9th would be better because if you start on a Thursday, then it will again go to the next week. It doesn't get over.
We are in Your Lordship.
All right.
9th.
List this case on 9th.
Obliged.
And whereas your lordships have issued notice because everyone has filed IAs. The notice is in the IAs.
All this notice.
On the IAs, because there won't be any fresh writ petition.
Notice on all the IAs.
Yes, correct.
Also in the fresh writ petition.
Yes, if
You
any.
must serve, all of you should serve.
Somebody must take charge, otherwise we get.
We'll serve.
Copies of time.
You must, Mr. Attorney, you must open a separate counter, demonetization counter.
I will consolidate all the counters.
One counter you must open.
If we say demonetization counter, Miller, lot of people have turned up.
What?
All right, sir. Thank you so much.
You're obliged.
Grateful.
Huh?
It is only demonetization.
All will come the same day, no? All,
Notices.
what do you want?
Notice.
Notice is issued in all cases. Wherever notice.
My currency was lying in court, Miller. When it was released in March, RBI said, no, I can't do it.
That we will solve. RBI is here, very much here.
Solicitor said that every possibility has been taken care of.
Uh,
It was seized while I was going to bank to deposit. Kalandra was lost, I was arrested, and then after 3 months, court found, income tax department also summoned, they cleared the money, released in March. Then RBI says, so I can't do that, it should have come before December.
That's their stand on affidavit.
That kind of.
Their stand on affidavit is we are not going to give anything. So it's all very well to soft pedal something here in the court and say, no, we'll look at individual cases. But their stand on affidavit is, we will not yield on this at all.
Don't say there's such a serious consequence.
Later also.
Don't say it's soft pedaling.
But
No, but then the learned solicitor made a statement in the morning. There is a provision which takes care of that situation.
That's right.
There's a provision which takes care of it. This court directed, please apply your mind and see whether these hardships can be addressed, etc. On affidavit thereafter, they have said, sorry, we have applied our mind and we are not going to yield on anything at all. That's the reason why we are all here.
all right, what we will do is, what we will do is, first let us solve this, answer these legal issues.
Yes, yes.
Then we will, on the basis of which we will take up each individual.
Great, very great. Very great.
First, let us take this main issue, then we will
Great.
take up each case.
Great.
That will be the first general order where you can.
Or relegate them.
Right.
for further.
Manoj, may I seek your lordship's indulgence for 1 minute, Manoj, on the same matter? All
Where
these
are you?
submissions, Manoj, I am a petitioner in person in serial number 27,
Yes.
petition number 943. All
Yes.
the submissions which has been urged before your lordships by Mr. Chindambaram is contained in my writ petition, all legal. Plus, there are other issues also which, Manoj, I will assist your lordships on the next date of hearing. So
All
the
right.
stand taken by the other side, it's not there. It's all the issues with the legal provisions are contained in my writ petition for your consideration, lordship's consideration.
Yes, sir. Give the number. I think you can take the number.
Manoj, it's writ petition number 943 of 2016,
Just
serial
check.
number 27.
Try to come to court, sir.
I'll come, Manoj. I was out of station. I'm so sorry, Manoj. I'll be there, Manoj.
All right, all right, all right. We'll have it on.
Grateful,
Great.
Manoj. Grateful.